Lord, may I be permitted to mention a matter? I am for the plaintiff in this commercial suit. I have filed a WS to the counterclaim of the respondent. It was filed in the department with the leave of the court on 25th. I was 6 days delay.
Huh?
It was for 6 days delay.
For filing?
For filing WS to the counterclaim of the respondent.
Filing counterclaim to the WS. WS to the counterclaim.
Yes.
When you receive the counterclaim?
I have received on 19th August and as per order, it was to file within 30 days. I was 6 days delay and with the leave of the court, I filed it on 25th. Now, only the formal acceptance of the court is required. It has been filed in the department.
Have you filed an application?
No, my lord.
For acceptance of return statement?
Then I'll do.
Have you filed any application? No. Who is for the other side?
I've not informed. I've just let it appear to be mentioned. I'll inform in the course of the day on Monday.
Tuesday it will come, inform the other side.
Yes, madam. Deeply.
Yes.
May I have your lordship leave to mention a commercial suit? Your lordship, this was last mentioned on 29th. Your lordship was pleased to direct to issuance of further notice upon the defendants and mentioned today, your lordship, we have given notice. An interim order was passed, your lordship, in favor of my client, which is subsisting till 31st of this month, your lordship. I'm humbly seeking an extension of that interim order. I have duly served notice upon the respondents.
Yeah, let me have matter. In view, there shall be an order of interim order to the petition when the matter shall be made. Huh? No, which means a regular bench for further consent. Yes.
Your lordship, we have served notice upon the respondents, your lordship. They have not appeared, not appearing today also. Again mentioning, lordship, we had earlier also served a mentioning notice on 28th before mentioning on 29th.
What you want?
Your lordship, extension of the interim order till the time the matter is heard, your lordship. We'll give another notice to the other side once the order is passed, your lordship.
Come at 1 o'clock.
Grateful, your lordship.
Before rising of the court.
Great.
Inform the other side.
Yes, your
Lordship, I'm mentioning for inclusion.
For what?
For inclusion in the list.
Why? Inclusion?
Your Lordship, there was a demurrer application which has been rejected and the matter is not in the list now. So I'm
Number one. Mention.
Huh?
Mentioning.
Yes, what mention?
Lord, for notice, Lord. This matter was fixed on 6th of December, my lord, for
6th of December.
I'm sorry, 6th of November. Lord, witness has some personal difficulty, my lord. He has to travel and he is traveling tomorrow, my lord. He will not be back before.
You are appearing for whom?
For the plaintiff, Lord. Lord, if your lordship kindly allows.
Bad shape of the file record.
I know, my lord, but
then I will dismiss or I will close. Nothing can be done. 20,000 cost was paid to you, imposed upon you.
I had paid.
You paid. Subsequently, defendant has asked for time. 25,000 cost upon the defendant. Now you are again asking. So there's nothing remains. It has to be closed. Your evidence is to be closed. One or the other reason you parties are in connivance with the parties are taking the time.
No, that is not the case here.
And making the fool to the party.
No, that is not the case here.
Sorry. Come on that. And keep it in mind. If it's not, then your case will be closed. Yes.
Item number 1.
May it please, my lord, I appear for the plaintiff. The lordship, in compliance of my lord's Order dated November 25, 2024, my lord. This substitute service has been effected, and this is my affidavit of service, my lord. And my lord, till date, my lord, no written statement has been filed, my lord.
Have you obtained report?
Lord, Lord, nothing has been
When they've
served.
entered appearance or not?
My lord, so far as, my lord,
You obtained report.
very well. Your lordship,
Without
kindly
a report,
direct,
how it will be?
kindly directs in the order, then, my lord, we shall obtain.
Huh?
My lord, kindly directs in the order, my lord, we shall obtain. My lord.
The matter is listed as to be mentioned on the prayer made by the counsel for the plaintiff. Counsel for the plaintiff submit that in terms of the order passed by this court dated 25th of November 2025, the plaintiff has made publication of the notice for the information of the defendant and has filed affidavit of service by enclosing the paper publication showing that the notice of this case has been published in the said newspaper. He submits that in spite of publication of the notice, none appears on behalf of the defendant. Accordingly, prays for fixing the matter in the list of fixing the matter in the list of undefended suit. Though the plaintiff has filed the affidavit of service by enclosing the paper publication showing the notice have been published in the English, Hindi, and Marathi English newspaper, but the plaintiff has not obtained any report from the department to ascertain whether after the publication of the notice the defendant have entered appearance or not. Counsel for the plaintiff prays for time to obtain report from the department. In view of the above, the case is adjourned. Let the matter appear on 11th November to submit report with regard to for submitting report to ascertain whether the defendant entered appearance or whether the defendant filed return statement.
Great, my lord.
My lord, appeared at my instance, my lord.
My
But
lord,
this relates to that, my lord. matter that
execution
we-
application, my lord.
Yes,
Yeah,
yes,
yeah.
yes, yes. On that day I
হ্যাঁ
passed.
ঠিক আছে
On that day, the
Madam,
learned advocate
But
has
only one thing to point out before Mr. Singh Mallet comments is, Mallet, on the last occasion on 27th on Monday, the matter was extensively heard. Lordship heard both the parties. Then
That's why I heard I passed. I have dictated the order. Subsequently,
The judgment that was cited, my
Mr.
lord.
Singh, yes, Mr. Singh has mentioned the matter, stating
And-
that at that time no, he has not gone through the judgment. Subsequently, find that the judgment is on the basis
Mallet,
of
if
the
you if
Hold that.
Bold Act
Pre-amended
for the
provision, my lord.
amendment. So he wanted to argue the matter.
Yes, I wanted to just, my lord, distinguish that judgment.
only two factual aspect, my lord. It is an execution application. Before filing of the execution application, we had duly, my lord, drawn up the decree. We had also applied for the certified copy. Now, my lord, particularly in an execution application where the modern approach is to complete it within 6 months, but for the bare technically, should it stand in the way? Should the decree holder be permitted to span at the will in this manner in an execution application?
No, but
May I
you
respond
file
to it?
the execution petition with the leave. It is not your case. The certified copy is not required.
No,
You
but
file
it's
the
duly applied. It is now for the department.
Correct. You file the execution petition with the leave of the court that he will produce the certified copy at the time of hearing of the matter. Now the matter has taken up for hearing and you are relied upon the Bombay High Court order, and this court, though this court has not taken cognizance but has
Yes.
directed that you have to file. But
Yes.
Mr.
But
Singh
only
has,
only
is
one thing
having
in
some
that.
reservation on this.
Yes, yes.
He wanted to argue.
Only one thing, but in that case, Mr. Bhattacharya was leading me in this matter, Mr. Rudraman Bhattacharya.
Tomorrow,
He had some medical difficulty today. He requested me so that
Tuesday?
matter can be Tuesday. my lord.
Tuesday, my lord. No
Tuesday,
problem.
my lord.
this is the matter on as per the
Same position, my lord.
as per the prayer made by the counsel for the decree holder.
Huh?
Please the matter on Tuesday under the same heading.
And my lord, in the meanwhile, the last day order should be uploaded. Where is my lord?
No,
Reserve
it
judgment.
cannot be, my lord.
Not the main one.
Uploaded. That's why you're not signed because before sign, Mr. Singh has
What is the-
mentioned the matter.
But without any special circumstance, should it be a regular course? Then everyone will come. Everyone will.
That's why
ask for
wanted to because chance is to be given. Let me
So
see
the
what is-
judgment was cited copy I did not
Let's
have, my
see
lord.
the what judgment
I want
is,
to
I think, then we'll come.
Deal with that judgment.
Okay.
Also, these properties are not the property of the judgment date, my lord, where the injunction was. I have got
Okay.
deeds, my lord, she'll show on the next date.
Okay.
সব মনে রাখবে কিন্তু। হ্যাঁ।
My lord, it's appearing for presentation of plaint.
Hmm.
My lord, it's a suit for goods sold and delivered.
Hmm.
If my lord takes the list of dates,
Hmm.
the last payment was made on 14th of October 2022.
14th October 2022.
Yes, my lord.
Yes.
And my lord, I am also entitled to exclusion of limitation for the period went through the mediation.
Hmm.
Because before approaching this honorable court, we have went to mediation,
Hmm.
wherein we have obtained the non-starter report.
When the mediation report is received?
My lord, the non-starter report is dated 14 September 2023.
That is within the limitation period.
Uh,
In September, within the limitation period.
yes, my lord. My lord, if my lord sees section 12, section 12A, subsection 3. Commercial Courts Act.
Yes.
Yes, my lord.
Correct. Provided, second proviso, provided further that the period during which the parties remained occupied with the pre-institution mediation, such period shall not be computed for the purpose of limitation under Limitation Act.
Yes, my lord.
So your last payment was made when?
Now, the last payment was made on 14th October 2022.
October 2022. So your 3 years is 13th of October 2025.
Yes, my lord.
Correct. That is a 3 years over. 13th October 2025, and you have submitted the mediation application on 26th of July 2023.
Yes, my lord.
26th of July 2023 you filed the mediation, and when you received the non-starter report, 23 itself.
Yes, my lord.
So that is within the limitation. It is not that you after the mediation or in the meantime you filed the mediation. It was covered the mediation.
My lord, my understanding is, my lord, even if it's within the 3 years time period, my lord, I will be entitled to exclusion of the time period in which I have participated in the mediation.
Great. During which the parties remained preoccupied if the 3 years completed, but within that you continue with the pre-mediation process. But your mediation was completed September 2023, prior to the 3 years. Prior to the 3 years.
My lord, in that case, my lord, it will never be exclusion of the specific time period. If my lord, I take it in that way that my limitation gets over and then I initiate the mediation, my limitation for filing the suit gets
Not
over.
limitation is over. Suppose your limitation is going to be on 25th of October 2025, but you have initiated the process in September or August, and it is continue till November. And November you got the non-starter report. Then your mediation, that 2 months period, you will get the benefit under the second proviso. 12 second proviso. But you have initiated the mediation process a year before. September 2023, you got the non-starter report. So
Yes,
how the court will give this exclusion period? Which period the exclusion is to be given? Your mediation was over by September 2023 itself.
Yes, my lord.
Check if you have any citations, you come. Otherwise, I have to deal with this.
Okay, my lord.
When you file this? When you file this?
My lord, this has been filed on
28th
28th.
October. 28th October.
And because of the intervening puja vacations, and then my lord, it's 2 days after the court reopened on Friday.
No,
And
your 25th October is the last date.
Yes, my lord.
Filing. And
20
25th October was the last date. And 25th October, there was a vacation when the court reopened.
My lord, the court reopened on 24th
October.
October.
Then that also you will not get that also. If you could have been filed on 24th October, you couldn't get it.
Yes, my lord. My lord, I am carrying one citation if my lord. My lord, if my lord comes at page 27 of the judgment.
Yes.
My lord, it's para quoted from Patil Automation. Para 99.4. It starts from page 26 and goes on to page 27.
Correct.
My lord, it says that the fact that the mediation can become a non-starter cannot be a reason to hold that the provision not mandatory. Apparently, the value judgment of the lawgiver is to give the provision a modicum of voluntariness for the defendant, whereas the plaintiff who approaches the court must necessarily resort to it.
Yes.
Section 12A elevates the settlement under the Act and the rules to an award within the meaning of Section 34 of the Arbitration Act, giving it meaningful enforceability. The period spent in mediation is excluded for the purpose of limitation.
Correct. I am not saying it is not excluded.
I'm getting it.
I am also of the view.
Provided it is after the limitation.
Yes, if on 24th October, your case is pending before the mediation, it is going on. And after that, your mediation non-starter report was given. Then it can be said.
Oh. My lord, if my lord can give me a chance, I can consider the judgment.
I am giving the chance. You go through. When you find anything, come on that. As per the prayer made by the counsel for the plaintiff, case is certain when?
My lord, any date after Tuesday?
Let the matter appear on 6th of November under the same heading.
Grateful, my lord.
Number 5.
I appear for the respondent.
Yes.
I appear for the petitioner, my lord. My lord, I pray for not today. I am led by my senior, Saurabh Ghosh.
What is the application for?
My lord, I am.
You are for the?
I'm for the respondent bank. The valuation report done earlier by the valuer, according to them, the valuer is very sick. He cannot come and depose. It's a converted commercial matter from the non-commercial. Now they have got a new valuer, has done the valuation. They want to, the evidence is being taken on commission. I'm cross-examining the other witnesses. Now they want to rely upon this valuation report. The per se I'm not opposing, with all points kept open for me to
cross-examine.
yes, I know. So I am not.
It is after the filing of the suit.
After the file, that I will take all points. I'll take all points kept open. If that can be ordered, I don't have any objection. But only thing today in the morning I came to know there.
My senior's
father expired today morning.
Demise for that.
His father expired today morning. That is the only thing.
As per the prayer made by the counsel for the plaintiff, the case is adjourned. When?
Fortnight.
Fortnight, my lordship.
Let the matter appear on 20th November.
Gratefully, your lordship.
Under the same heading.
For the plaintiff respondent in this matter, Lordship.
My lord, there is some delay, my lord, in filing the written statement. But, my lord, we have taken leave on 28th and, my lord, filed.
When you receive the writ of some...
my lord, around, my lord, 9th July 2025. The 30 days expired on 7th August 25. 120 day, my lord, will expire on 6th November. My lord, I've already...
Before?
Yes, before.
Yes.
I can't stand in the way, my lord, just because of formal objection to this. Stand in the way otherwise. It's within 120 days.
Yes, and my master summons says, my lord, 81 days.
Superintending Engineer, Southern Highway Circle. The sole defendant.
told
The
defendant.
defendant has filed the present application being GA-1 of 2025, praying for condoning the delay in filing written statement. Counsel for the defendant submit that the defendant, office of the defendant received the writ of summons on 9th of July 2025. They submit that the plaint consists of 3 volumes and several documents, and as such, the defendant was in search of all the documents to prepare the written statement. By that time, the period of 30 days for filing the written statement was over. But the defendant has prepared the written statement and affirmed the written statement on
Miller 28th
28th of
October 2025.
on 28th of October 2025, and with the leave of this court has filed the written statement in the department subject to acceptance by this court. The counsel for the plaintiff submit that though the defendant could not file the written statement within the period of 30 days, but have filed the written statement within the outer period of 120 days, and accordingly the period for acceptance of the written statement. Per counsel and advocate appearing for the plaintiff raised objection and submit that the defendant is the superintending engineer of the government of West Bengal, and they are having their document in the office, and as such the cost shown by the defendant is not sufficient to condone the delay and pays for rejection of the application. Had the learned counsel for the respective parties peruse the materials on record. This could find that though the defendant could not file the written statement within the period of 30 days, but have filed the written statement within the outer period of 120 days, and have categorically stated that the plaint filed by the plaintiff consists of 3 volumes, due to which the defendant consumes time to prepare the written statement after searching out all the relevant documents from the office of the defendant. She has also taken the plea that there was a Puja vacation and the advocates were and the court was holiday, due to which the court was holiday and due to which the advocate on record could not prepare the written statement. Had the learned counsel for the respective parties, this court find that the plaintiff and defendant has shown sufficient cause for non-filing of the written statement within the period of 30 days, but have filed the written statement within the outer period of 120 days, and as such, this court is of the view one opportunity should be given to the defendant to file written statement. Accordingly, written statement is accepted subject to payment of cost of rupees 3,000.
There was a vacation, Millard, for 1 month. Millard.
Law provision provides some cost, 2,000 to the High Court Legal Service Committee within a week from date. The department is directed to accept the written statement subject to scrutiny by the department. The defendant is directed to serve the copy of the written statement by.
No, written statement has already been filed.
Already filed.
It is submitted.
Just be accepted.
No, submit.
Already.
For the defendant submitted the written statement already. There is no counter claim. Any counter claim? Already submitted. Already supplied the written statement to the plaintiff. CA comes and
Grateful also.
Item number 7, Your Lordship, I'm for the defendant.
And I'm for the plaintiff, my lord.
There were 2 applications. One application was for condonation of delay in filing the written statement. That is GA2, Your Lordship,
yes,
on the board. Now, insofar as the condonation application is concerned, I had obtained leave from Your Lordship to file the written statement with the department. The endorsement is of 25th of August 2025. I had filed it. The writ of summons was served on 8th of August. So technically, there is a delay of 17 or 18 days. And even if taken holistically, I'm filing the written statement within 50 days. So much before 120 days. So that is my prayer for condonation of delay in filing written statement. Your Lordship will find the endorsement at the back of the written statement, Your Lordship, filed with the department. The department was pleased to take it on record. Pursuant to Your Lordship's leave and pursuant to the outcome of this GA. That is my first application, GA2. And insofar as GA3, I have another application, Your Lordship.
What is the GA3?
GA3 is a demurrer, Your Lordship, Order 7, Rule 11. Because there was an earlier suit filed by the plaintiff. That suit was
you'll file affidavit.
They would need to file.
And with regard to 2, you have any
leave it to Your Lordship.
record or not? Sole defendant. Only one defendant.
Yes,
Only one
Lordship,
defendant.
one defendant.
The defendant has filed the present application
dependent.
in GA Com
Dependent
2
petitioner.
of 2025,
Plaintiff
praying for condoning the delay in filing return statement. Counsel for the defendant submitted. The defendant has received the writ of summons on 8th of August 2025. 8th of August 2025.
8th of August.
8th of August.
Open the document, please, number.
After receipt of the writ of summons, the defendant has contacted the advocate on record for legal advice, and accordingly, as per the advice of the advocate on record, defendant had provided all the documents to the learned advocate on record, but in the meantime, the period of 30 days was over. But the defendant has affirmed the written statement on. When you are affirmed the written statement?
The affirmation of the written statement is on 12th of September 2025 affirmed.
2025. That is within the outer period of 120 days. We submit that.
What are the
Endorsing submit that there is only 17 days delay in filing the written statement, and if the court 17 days in filing the written statement. Police counsel for the plaintiff raised objection and submits that the defendant has not shown any cause to condone the delay for filing the written statement, and he prays for his rejection of the present application. Had the learned counsel for the respective parties peruse the application, peruse the materials on record, this court find that admittedly the writ of summons was served upon the defendant on 8th of August 2025. The defendant ought to have filed the written statement by 7th of September 2025, but has filed the written statement. When you have filed the written statement, but has affirmed the written statement on
12th of September.
On 12th of September.
12th September. On
12th September, it was affirmed.
25, and with the leave of this court has submitted the same in the department subject to acceptance by this court. Considering the above, this court find that though the plaintiff has not, defendant has not filed the written statement within the period of within the statutory period of 30 days, but has filed the written statement within the outer period of 120 days. And as such, this court is of the view that the plaintiff should be given one opportunity and defendant should be plaintiff new. Accordingly, the written statement is accepted subject to payment of cost of ₹2,000 in the High Court Legal Service Authority within a week from date. Police department is directed to accept the written statement subject to scrutiny by the department. Have you served the copy?
We have served a copy.
The plaintiff and defendant already served the copy of the written statement to the plaintiff. There is no counterclaim.
There is no counterclaim.
GA number 77 dispose.
Only one indulgence, Your Lordship, instead of 7 days, if it could be 10 days.
Okay, 2 weeks.
And another indulgence, Your Lordship, I seek to file a supplementary affidavit in GA3 to bring on record the previous suit.
Dispose of record. The Defendant has also filed an application under an application GA 3 of 2025 under Order 7 Rule 11 of the Code of Civil Procedure for rejection of the claim. The defendant prays for leave to file supplementary affidavit by disclosing the plaint along with the document of the previous suit. Such leave is granted. Let the supplementary affidavit be filed by
Within 2 weeks, Your Lordship.
within 2 weeks after serving the copy to the learned counsel for the plaintiff. The plaintiff has liberty to file affidavit in opposition within 3 weeks.
3 weeks after I get the
3 weeks after getting the supplementary affidavit, if any, filed by the defendant, and reply, if any, there to be filed within 2 weeks thereafter. List the matter. 2 week. 7 week. 23rd December.
Very
grateful to your lordship.
I'm deeply obliged, Your Lordship.
Item number 8, your lordship, I am for the defendant.
Yes.
They filed an application for the acceptance of the written statement because it was, your lordship, filed, your lordship, on 121st day. For the other side, no, on 119th day. 121st day, your lordship, is out of time. They have taken one, your lordship, the objection, your lordship, that prior to that, your lordship, it has been served, your lordship, through speed post. So I wanted to show your lordship regarding Order 29 Rule 2A. Your lordship has indicated that no, why Order 29 Rule 2A? Order 29 Rule 2B is for the speed post and it has been served prior to that, then there is an option. If your lordship kindly take, your lordship, the objection where your lordship, they have annexed to your lordship the service report once. Affidavit in opposition.
Yes.
Now, if your lordship kindly sees, your lordship, the annexure A,
Yes.
that is page 7. If they have given two type of services. One's, your lordship, through bailiff, and the second one, your lordship, through speed post. Now, if your lordship kindly sees the first column, it says the material to be served, one duplicate copy served by Ranjit Chakraborty, seal bailiff. Date and time and time of service is 22nd of November 2024. I have, your lordship, accepted it. I said, yeah, okay, 22nd of November 2024 is the date when I have received the summons. Now, 120 days is going to expire on 22nd of March 2025, and I file the returns, because dates are important. I file the written statement with the leave of the court on 21st of March 2025. That's an admitted position. 21st March 2025.
You filed?
Yes, with the leave of the court, I have filed it with the department. 120 days, your lordship, is going to expire on, was going to expire on 22nd of March 2025.
Yes.
Now, your lordship, kindly take the affidavit in opposition again.
So, if you are taking to the service of 22nd 11,
then
you are in 120th days, you are within time.
I'm within time. The courts have powers, your lordship, to condone by delay.
Okay.
Now, the point which they have taken is the second column. The second column, what it has happened, your lordship, that it's showing, your lordship, 13th of November 2024 dispatched, and your lordship, is item delivered on 14th of November 2024. Now, on 14th of November 2024, and your lordship kindly sees also that neither a postal acknowledgement receipt nor an undelivered packet. Now, the question is, your lordship, if on 14th of November 2024, the principal officer or a director has received it, then I'm out. Then I don't have any choice.
Correct.
Because we have said that this on 14th of November 2024, your lordship, we have not received the summons. Now, the question is whether the summon has been served upon the director or a secretary or a principal officer. That is required. Now, your lordship, kindly take Order 29 Rule 2B, and I will show your lordship where your lordship is stuck in connection with Rule B.
Order 29 Rule?
Rule 2, A and B.
Yes,
Service on corporation.
correct.
Subject to any statutory provision regulating service of process where the suit is against a corporation, the summon may be served A. on the secretary or on any director or other principal officer of the corporation. Now, your lordship has indicated here it is mentioned or.
Yes.
And the B, your lordship is troubling your lordship at whether it should be, if it is served through speed post, then it's a complete service. Lordship kindly sees. B, by leaving it or sending it by post address to the corporation at the registered office, or if there is no registered office, then at the place where the corporation carries on business.
Correct.
So your lordship's view was that if B is completed, then A is not required. Or my submission was, your lordship, was first is the criteria is the BA. Once A is not satisfied, then the B comes into picture. I'll show the authorities, your lordship. Lordship, kindly take, your lordship, the annexure. Why it is important? Lordship, the rule is the bailiff has to first go. Now, bailiff, if the bailiff, your lordship, is obstructed, is the director or the secretary has refused, then the normal procedure is, then he has to basically paste that particular summons on the wall at a conspicuous place, and then he'll come back. I'll show your lordship Order 5 Rule 17, and there's a Supreme Court on that. I'll clearly mention. Now, what is, your lordship, the problem here? That in Code of Civil Procedure, when actually, your lordship, is in 1908, at that point of time, Order 8, Rule 1, your lordship, was not mandatory, it was a directory. Now, we have to also understand that now Commercial Courts Act come into force. Once, your lordship, this is done, 120 days, I am out. So, therefore, the service of summons, your lordship, has to be perfectly served on a particular person. Otherwise, I will lose my right to file the written statement.
Correct.
Now, your lordship kindly sees what is lacuna in this service report. Now, the bailiff has not gone first. Here, he sent, your lordship, the speed post first. Lordship kindly sees, your lordship, the column. It's 14 November 2024. If the bailiff, if the sheriff's department is confirmed that on 14 November 2024, the summon has been properly served, there is no question of sending again through bailiff. That's why the bailiff has gone on 22nd November 2024. I am saying that I have received the summon on 22nd November 2024. The main thing is when which date is to be required to be taken. Either it is 22nd November 2024 or 14th of November 2024. From the report, it's not shown that any of the director has received it. From at least, your lordship, the postal service report, your lordship, is not showing. I don't know, your lordship, what the serving officer, your lordship, because in a bailiff's office or sheriff's office, the serving officers, your lordship, files an affidavit. Now, in the affidavit, if he writes, your lordship, that on 14th of November 2024, the director or a secretary or a principal officer has received the summons, then, your lordship, I cannot urge this particular point that on 22nd November, subsequent date should be taken, and why not 14th of November 2024?
What is the cost title of the defendant?
Your lordship, kindly sees. NTC Industries Limited.
NTC Industries Limited.
Yes, it's a corporation.
If suppose,
yes,
if suppose the bailiff went, it is not the bailiff will not go to the officer concerned and serve the copy.
Yes.
The bailiff is also go to the office in the dispatch. It will given to the dispatch section or dispatch counter, whatever it may be, or the dispatch clerk, and he will take the signature. So what will happen to that on that?
My reading
situation.
Yes, lordship, my reading is, because I'll show your lordship the authority. The bailiff has to first go and ask for, your lordship, the director, secretary, or principal officer. If they
see, bailiff is not aware with regard to the Order 29 Rule here to whom it has been served. Bailiff is only concerned with the addressee, and you have given the address name of the company. It is not by name. If it is a name, then your submission could have been taken into consideration. Yes, it is a name. It has not been served to the named person, and it has not been given. But you have mentioned with regard to the NTPC, whatever it may be. Correct. So bailiff will go to the office, and there will be a system, dispatch clerk or what, receiving clerk or section, whatever it is. It is so. What would be situation on that?
Yes, your lordship. Then, your lordship, I have to show your lordship that authority. Your lordship is an old one. What has happened, your lordship, in this particular circumstances, when, your lordship, the commercial suit or non-commercial suit, the bailiff has to go because the person is going. He has to first go, and if there is a corporation or a company, it is his duty to first cast where is the director, who is the secretary, who is the principal officer. If he refuses,
then in the report he has to mention it. Lordship kindly sees the judgment and then Your Lordship, I'll place Your Lordship. This is 1980 3 SCC 595 at a copy of sir. Now, Your Lordship, kindly take paragraph 6. Paragraph 6 onwards. Your Lordship.
Yes.
Paragraph 6, Order 29 of the Code is headed sued by or against corporations. There are only 3 rules in it. We are concerned with Rule 2, which reads as follows. Subject to any statutory provisions regulating the service of process where the suit is against a corporation, the summons may be served. This is Your Lordship statute, I have read it. Now, Your Lordship kindly sees, Your Lordship, the unnumbered para. Rule 2 is not exhaustive provision providing for all modes of service on the company in the sense as to what is meant by service of summons on the secretary, director or principal officer. In Jute versus Gunny Brokers Limited versus Union of India, it was held that the word principal officer in clause A of the rule will include managing agent and it can, under this rule, be on a juristic person. Accordingly, service on the managing agents who are corporation is valid under clause A. The meaning of clause B, now Your Lordship, the B is coming into the picture. The meaning of clause B has got to be understood in the background of the provisions of the code in order 5, which is meant for issue and service of the summons on natural persons. Sending a summons by post to the registered office of the company, unless the contrary is shown, will be presumed to be service on the company itself. But the first part of the clause A has got to be understood
Clause
with
B.
reference. Yes, I'm sorry. But the first part of clause B has got to be understood with reference to the other provisions of the code. Now, in Rule 17 of Order 5, it has been provided. So, Your Lordship, the interpretation is we have to also see Order 5, Rule 17. Now, Lordship, may I place it? Whether the defendant or his agent or such other person as aforesaid refuses to sign the acknowledgement or where the serving officer, after using all the due and reasonable diligence, cannot find the defendant and there is no agent empowered to accept service of the summons on his behalf, nor any person on whom service can be made, serving officer shall affix a copy of the summons on the outer door or some other conspicuous part of the house in which the defendant ordinarily resides or carries on business or personally work for gain, and shall then return the original to the court from which it was issued, with a report endorsed thereon or annexed thereto, stating that he has so affixed the copy, the circumstances under which he did so, and the name and the address of the person, if any, by whom the house was identified and in whose presence the copy was affixed. Sending summons to a corporation by a post addressed to it as its registered office may be a good mode of service, either by itself or preferably by way of an additional mode of service. But leaving the summons at the registered office of the corporation, if it is literally interpreted to say that the summons can be left anywhere uncared in the office or registered office of the company, then it will lead to an anomalous and absurd result. It has to be read in the background of the provisions contained in Order 5, Rule 17 of the Code. In other words, if the serving peon or the bailiff is not able to serve the summons on the secretary or the director or any other principal officer of the corporation, because either he refuses to sign the summons or is not be found by the serving officer, even after due diligence, he can leave the summons at the registered office of the company and make a report to that effect. In the instant case, nothing of this kind was done. It was not the case of the respondent in his rejoinder filed in miscellaneous case that the service of the summons was effected in accordance with the first part of Clause B of Rule 2 of Order 29. Annexure A of the counter affidavit filed by the respondent in the petition filed by the appellant under Order 9, Rule 13 of the Code. In Para 9 of the petition, it was stated And then your lordship kindly sees, your lordship, the unnumbered, because this is, your lordship, the case of the matter, paragraph 9 of the petition, the rejoinder, and nowhere in the rejoinder stand it was taken that the summon was duly served on the company, but it was left at the registered office of the company. Reference to Madhya Pradesh Amendment to Order 9 Rule 13 is immaterial. So my humble submission is, first you have to discharge your first burden. The bailiff has to go, search your lordship, where your lordship is the secretary, director, or the principal officer, or the managing agent. If that is refused, then the person, your lordship, has to affix that particular summons at the conspicuous place. Thereafter, your lordship, for your lordship, abundant precaution, the B is coming into the picture. Then they will send a registered post, and that is received. Then your lordship, the summon is completely received by the other side.
Okay.
So here, your lordship, one thing is important. The bailiff, your lordship, has first not gone. The bailiff, your lordship, first sent your lordship a registered post. And thereafter he has gone. My humble submission is, whenever the bailiff has gone, your lordship, the director has received it. So why, your lordship, this particular 14th November 2024, your lordship, is taken into consideration? The reason is, if it is received by the, your lordship, the director, or the, your lordship, the secretary, or the managing agent, I can understand. But your lordship, on 22nd, because there, your lordship, I am not saying, because there are two dates. If I am saying, your lordship, I have never received, the things are different. But here, your lordship, one date I am accepting it, 22nd. 14th, your lordship, kindly, your lordship, directs your lordship, the serving officer, to come and show that no, this particular, your lordship, the addressee is the, your lordship, the director, or your lordship, the company, or the secretary, or the principal officer, the matter will be ended. But here, why, your lordship, the department will serve on 14th of November through speed post? He has to first go and discharge his burden. And your lordship, this is a commercial suit. And your lordship, I will be defenseless, your lordship, if your lordship will not take this 22nd November. When, your lordship, the bailiff has gone.
No, so see,
Yes, sir.
if a person has taken, but normally you all persons are taking both the ways. But in the normal suit, I find in the original side, in the normal suit, first it has to go by the bailiff. Secondly, if it's a return, it has to go by the postal. Then it is not, then it is the pasted. Then it is not, then the substituted by way public. These are the procedure under the rules.
Yes.
But here what's happened now, you persons are filing the suits, giving the requisites both ways. Both ways. And both ways, the bailiff has nothing to do. If he has received the summons, writ of summons from both sides,
Yes,
from the postal also, from the bailiff also, he has to do the work.
Yes.
Then he is sending in both the way.
Yes.
So he cannot say, no, first I have to send this and I have to buy. So he has sent this. Now the only question is which receipt is to be accepted.
Yes, sir.
As per your case, you have received, as per the mode of service, you have received on 13/11 by postal.
That's their case.
There, you are telling that non postal you have not received, and you have received on 23rd from the bailiff.
Yes, sir.
And you are taking the benefit of that order 29 rule 2, right with section right with
Yes,
order 17 rule 5 of the
Yes,
order 5 rule 17
7.
of the CPC. Let us see. Yeah,
Yes.
and then it has to. Then the report is to be called for. Yes,
sir,
Mr.
Let the report
let
come
me,
here from the
Mr.
serving officer.
Let me hear, Mr.
Yes, yes. And we
Thakkar,
will also show you, I think Mr. Thakkar will certainly show, Your Lordship, the original side rules. Your Lordship, because the lower court here, what happened, Your Lordship, they follow the civil rules and orders. But here, Your Lordship, with the original side rules, we have to
that's
first
why
see,
that's
yes,
why
Your
I'm
Lordship, that whom, because Lordship, if these arguments may or may not be actually put forward, if it is a normal suit. But here, Your Lordship, the kind
That's what I'm telling,
appreciate the
because
situation, I would
that's why I asked for the, because in the normal suit these are the procedure.
Yes, yes.
Now it is
Lordship
the original side rules. We have to go now.
Exercise the discretion and allow me. But here, Your Lordship can't exercise the discretion.
What the criminals
Report
commercial practice rules है ना?
practice rules. Code has been defined, Code of Civil Procedure. Service of process by courier fax and service of I think Rule 10, Your Lordship, will be Rule 10. Service of process by courier, fax, and electronic mode stroke short service. That is, Your Lordship, the electronic mode of
Electronic mode of
Yeah.
that has been included.
Yes, sir.
Nothing. They have not given any further.
Then Chapter 2, 12, service through courier.
Hmm.
I have not actually checked, Your Lordship, this procedure. Chapter 2, Chapter 3, 4 is again electronic mode. Service of summons, courier service.
Chapter 1 and Chapter 2. Commercial Division or Commercial Appellate Division in the High Court, the commercial courts at the district level may be on its own motion or the application on the party also direct the service in diverse processes, notice, and so. The original side also. Yes, Mr. Tucker, what is your submission?
The entire argument of my learned friend is premised on, kindly see, the greatest of respect, an incorrect interpretation of Order 29.
Yes.
Rule 2. He says, first, attempt must be made to serve by hand. He says the bailiff of this honorable court must first go to the registered office of the company, find out who the secretary, director, or principal officer is, that is 2A, and then only, if not found or refused, sent by speed post. That is his entire submission. That is not to be found in Order 29 Rule 2. It's not to be found. This gives alternate modes of service. It is also not to be found in the original side rules. So there is no, what he's submitting that the bailiff should have first gone and not sent by post is not to be found. Number one. Number two, now kindly see the judgment which he has cited for this proposition. What does the judgment say and what happened in that case? The judgment in fact supports me. Kindly come to it. Kindly see paragraph 6 once, please, my lord, where Order 29 is extracted. Now kindly see paragraph 7. But before I trouble your lordship with paragraph 7, kindly come to the next page, my lord, where paragraph 8 is continued. Kindly see the first paragraph at page 598, the last page of the judgment. I'm sorry, my lord, kindly come to it.
Yes, yes.
In other words, kindly see the last sentence of paragraph 8 at the bottom of page 597.
597.
Yes.
In other words, yes.
In other words, if the serving peon, kindly see now. In other words, if the serving peon or bailiff is not able to serve the summons on the secretary or any director or any other principal officer of the corporation, because either he refuses to sign the summon or is not to be found by the serving person even after due diligence, then he can leave the summons at the registered office of the company and make a report to that effect. In the instant case, now kindly see, my lord, in the instant case, nothing of the kind was done. It was not the case of the respondent in its rejoinder filed in the miscellaneous case that the service of the summons was effected. Kindly see now, what the court is considering is only the first part. was effected in accordance with the first part of clause B of rule 2 of order 29 of the court. Kindly turn over, my lord, to page paragraph 6 once, where the first part is by leaving. This judgment does not consider the second part at all. The facts of this case was it was left
Only first.
Yes. The facts of the case, now kindly see. It was not the case that the first part, Annexure A to the counter affidavit filed by the respondent in the petition filed by the appellant under so-and-so, in paragraph 9 of the said petition, it was stated, inspection of record of this honorable court relating to the service of the summons reveals that the bailiff of the small causes court at Calcutta, now kindly see, seems to have delivered a copy of the summons to a gentleman who is described as an office assistant on such and such date. No office assistant of the defendant company is empowered or authorized to receive summons. Original summons which has been returned by the bailiff has been signed by one Navlakha. Navlakha was merely concerned with sales, has nothing to do with legal matters generally or with receiving summons in particular. Service of the summons of Navlakha cannot be regarded as due service. So, my lord, it was served by hand by the bailiff on a person who was not a director, secretary or principal officer. So I adopt my learned friend's submissions. If the director, principal officer or secretary cannot be found, then it has to be affixed. It cannot be left in the hands of the
other person.
Yes, of the doorkeeper. It cannot be, then it is not due service. So this is a judgment. This judgment is an authority on what is meant by leaving. That is the first part of 29 statutory B, not the second part or by registered post. And what is registered post is correct. Now kindly see 7.
Yes.
The meaning of clause B, now kindly see 7. The meaning of clause B has to be understood in the background of the provisions of the code in order 5, which is meant for issuance service of summons on natural persons. Now kindly see, sending a summons by post to the registered office of the company, unless the contrary is shown, will be presumed to be service on the company itself. This is what we are concerned with. Service by registered post is presumed to be service on the company. Then kindly see, but the first part of clause B has to be understood with reference to the other provisions of the code in rule 17 of order. So what is first part of clause B? That is by leaving. So we are not concerned with leaving. The rest of the judgment is only on leaving in the hands of a natural person who is not competent in terms of A.
Yes.
Now this judgment nowhere supports Mr. Sengupta's submissions that it has registered post is a secondary service, not first service. There is a passing observation which he read out in paragraph 8. Sending summons to a corporation by post addressed to it at its registered office may be a good mode of service either by itself or preferably by way of an additional mode of service. But this does not change the law. And nowhere does this judgment say that sending by registered post is not good service. In fact, it says in paragraph 7, unless is deemed to be service on the company itself. And this service by registered post was not in issue before the Supreme Court in this case.
Yes.
What was in issue was the first part, leaving it in the hands of a person who is not a person named in A.
Yes.
So this judgment, my lord, with the greatest of respect, has no application in the facts of the present case.
Yes.
Now, my lord, kindly see where the Supreme Court has dealt with service by registered post, what it has to say. 2002 7 SCC 531. Now, unko do.
Yes.
The sole questions, and here, my lord, of course, it was not an individual, it was not a corporation, it was an individual. The sole question that falls for consideration in this appeal is whether the service of notice sent by registered post with acknowledgement card in terms of Order 5, second proviso to Rule 19A of the Code of Civil Procedure, read with Section 27 of the General Causes Act, can be accepted as a sufficient service. Kindly see Order 5, second proviso. Kindly see, my lord. Rule, because this is applies to individuals. That is the only difference. Otherwise, provision is the same. Kindly see. Issue and service of summons. This is general. Now kindly see, my lord.
Yes.
Then, my lord, kindly come to paragraph 9, please. Because here also recalling of ex parte decree was taken out. Order 5 provides that where the summons are properly addressed, prepaid, and duly sent by registered post with acknowledgement due, notwithstanding the fact that the acknowledgement having been lost or mislaid, or for any other reason has not been received by the court within 30 days from the date of the issuance of the summons, the court shall presume that notice is duly served. Further, Section 27 of the General Clauses Act, in short, the Act provides similar provision. The presumptions are rebuttable. It is always open to the defendants to rebut the presumption by leading convincing and cogent evidence. Now, my lord, kindly see to our case, serving by post addressed to the corporation at the registered office. That is what we are concerned with. Now, it is nobody's case that the postal address of the defendants are not properly addressed and therefore the registered summons could not be served. It is also nobody's case that the registered summons are not prepaid and not duly sent. In fact, the registered summons bearing receipt number so-and-so were issued is borne out from the record. Once it is proved that summons was sent by registered post to a correct and given address, the defendant's own conduct becomes important. Now, the rest is on conduct, but it leads to a presumption that this has been served, and the service in this case has been carried out by a Lordship's department. It is not that I have carried out any service.
Yes.
Now, there is a judgment of this Honorable Court on this, my lord, where your Lordship has noticed. Kindly come to paragraph 4. Page 4, please, my lord, where your Lordship close the right to file written statement. Kindly see paragraph 4. Consider the submission, page 4. Consider the submissions made, and then your Lordship's judgment starts. The defendant number 1 has denied service of writ of summons by speed post on such and such date. The submission of the learned counsel for the defendant number 1 cannot be taken into consideration, as the defendant number 1 has not annexed any contrary documents to show that the report submitted by the deputy sheriff is not correct. It is found that in the service report the date is mentioned as so-and-so, but accordingly the date of the report which is reflected in the signature. This court in every suit relied upon the report of the deputy sheriff, and on the basis of the report of the deputy sheriff, the court is ascertaining with regard to service of writ of summons upon the defendant. In the present case also, the deputy sheriff has submitted the report, and the report reveals that in both the modes, the writ of summons was served, that is by hand on such and such date and by speed post. Now kindly see, my lord, hand is on 3rd February, speed post on 16 January, that is prior. Thus, the submissions made by learned counsel for the defendant that the writ of summons was not served on 16 January cannot be relied upon. The defendant number 1 in the prior portion of the present application has paid for allowing him to file the written statement within 120 days. It is found from the record that the application was affirmed on 5th January, but the application was filed on 13th January, that is after the period of 120 days. Thus, the prayer is also defective. In the case report, the Honor has judgment passed in so-and-so time for filing written statement in commercial contracts is mandatory, and court lacks discretion to condone the delay. In the present case, then your Lordship has noticed the Supreme Court decisions. In the present case, admittedly, the defendant number 1 has not filed the written statement, though it is affirmed. The defendant number 1 has filed the application on 13 June 2023, that is after the period of 120 days, which is calculated, my lord, from the date of service by speed post.
Yes.
So, my lord, the first of the 2 dates is taken. There is a presumption in law that a document sent by registered post, even if no acknowledgement received, etc., is there. The report filed by the sheriff, my lord, unless it is proved to be incorrect by leading cogent evidence, has to be believed. And my lord, order 29 2B provides for this mode of service, sending it by post addressed to the corporation at the registered office.
Yes.
So, this is exactly what the department has done. There is no law shown to your lordship that first A must be exhausted, then B must be resorted to. That is not the law. What the procedure followed by the department of this court seems to be, my lord, that both modes are done so as to give him ample, my lord, notice. And admittedly, my lord, he has, if my learned friend has fairly not submitted that he has not received the speed post. He is saying the second date must be counted because that is the date when it was served in compliance with A. My lord, as far as the order 5 provision is concerned, my lord, that has been subsequently removed, but I have shown your lordship that judgment because the corresponding provision as far as service on corporation is concerned is still kept.
Correct.
This paramateria provision, my lord, in case of corporations has been kept, my lord, has been retained in the code.
Yes. That's all.
Please.
Two things are very important. The HON'BLE judgment, I am not disputing, your lordship. 120 days beyond, your lordship has correctly, your lordship, closed it. Now, your lordship, before your lordship showing, your lordship, maybe your lordship, I cannot say he's made a wrong submission, but maybe skipped, your lordship, kindly take, your lordship, the original side rules. Original side rules, your lordship.
Yes.
Now, we have to follow, your lordship, your lordship, the bailiff's office has to follow. Now, your lordship, kindly take chapter 8, rule 21. Because chapter 8, rule 15 starts with appearance of the parties and service of process. Lordship,
Yes.
your lordship, kindly take. Now, rule 21 is the proof of service of summons.
Yes.
Unless the court or a judge shall otherwise order, the service of the writ of summons shall be proved by a production of service certificate of the register or of appearance having been entered, or where no appearance has been entered, by evidencing showing that the summons was served in a manner provided by the code. Here code means the code of civil procedure. Such proof shall ordinarily be by the affidavit of serving officer, and as to such matter as the serving officer cannot speak of his knowledge of the person who attended the serving officer for the purpose of identification at the time of the service, or such other person or person can speak to the identity of the person served or to the matter necessary to be proved in respect of the service. Now your lordship kindly sees 24A. That is your lordship service by registered post.
Correct.
Service of any notice, summons, order or other document not being the writ of summons issued under this chapter, in respect of which personal service is not requisite, upon a party who has not entered appearance, and upon a person not a party to a suit or a matter whose residence is within the jurisdiction of the another court in Union of India, and between which the place and Calcutta there is a communication by registered post, may, where so directed by a judge or by the register of the master, be effected by posting a true copy of the document required to be served in a prepaid registered envelope addressed to such party or the person at the place where he is residing, provided that the time at which the documents so posted would be delivered in the ordinary course of the post shall be considered as the time of the service thereof. So therefore, there are two different type of modes. One is the bailiff and one is this registered post. Now, from the report, it is not showing that the registered post or the speed post, whatever it may be, has been served upon the director or the company or the secretary or the principal officer. Moreover, if your lordship kindly sees, CPC's order 5 rule 19A has been omitted, has been deleted. Apart from that, your lordship kindly take order 5 rule 19A. Because earlier your lordship is order 5 rule 19A was simultaneous issue of summons for service by post in addition to personal service.
Yes.
Your lordship, this is the earlier one. Order 5 rule 19A. Your lordship is
simultaneously the summons.
Yes, yes. So therefore, that was an simultaneously has been given specifically, your lordship, the earlier code of civil procedure. Now the court shall, in addition to and simultaneously with the issue of the summons for service in the manner provided in rule 9 to 19 also directs the summons to be served by the registered post, acknowledgement addressed to the defendant or his agent empowered to accept the service at the place where the defendant or his agent actually or voluntarily resides or carries on business, provided that nothing in the sub-rule shall require the court to issue a summons of service.
Where from you reading?
Your Lordship, Order 5, Rule 19A.
Achha.
Your Lordship, that was the earlier one.
You are
That's why,
having
Lordship,
the
I
old
wanted to
copy?
show Your Lordship that this has been omitted, Your Lordship,
Yes.
sometime in 2002.
2002.
So therefore, today, the Code of Civil Procedure, Your Lordship, is not actually having this Order 5, Rule 19A. So therefore, the judgment cited by Mr. Thakkar, Your Lordship, has no relevance right now. It may be the suit has been filed prior to 2002, Your Lordship. This particular provision, Order 5, Rule 19A, may be applicable. Moreover, if Your Lordship kindly sees, Order 5, Rule 20A has also been omitted. That is, Your Lordship, the service of summons by post.
Then what about this practice direction of the commercial code?
Practice direction of the commercial courts, Your Lordship, has to be followed in view of, Your Lordship, the prevailing law, Your Lordship, right now. Now, my situation, Your Lordship, is a little bit different from others. Here, Your Lordship, there are 2 dates. Now, if, Your Lordship, the serving officer, the report of the serving officer is very important. If the report of the serving officer is very clear that this particular registered post or the speech post has been received by the director, principal officer, or secretary, then I'm gone.
Then you have to prove. You have to prove.
Your Lordship, I cannot take, Your Lordship, that particular affidavit of the serving officer. Either Your Lordship will direct them, or Your Lordship, they will file a report before the court. The reason is very simple. If it is not there in the serving officer's report, Your Lordship, I am through. Because there are 2 dates, commercial suit, Your Lordship, some benefit of doubt has to be given to me. Because today, Mr. Thakkar could not show from the affidavit, Your Lordship, that it has been served upon, Your Lordship, the secretary, director, or a principal officer.
Admittedly, with regard to the 14th, the first and 14th of November, it has been to the registered post. Admittedly, registered post, it can't be to the same officer, it will be in the office.
Maybe.
And as the judgment which the Thakkar has relied upon, it is registered post is a good service.
Is a good service.
Good service.
But Your Lordship,
Now you are telling that has been omitted. So whether the registered post is to be taken into consideration or not, that the court will take.
Yes, Your Lordship. 19A has been omitted, 20A has been omitted.
Correct. Now with regard to the 22nd of November.
Yes.
22nd of November.
I'm accepting it.
You are accepting that you have accepted and you have received that. So now only the question whether it is to be taken on 14 November or 22nd.
Or 20th.
If it is taken on 14 November, you will be out.
I'm be out.
If it is taken on 22nd November, you will be in. That is the question.
Yes. And 14th November, my submission is it has to be Order 29, Rule 2A and then 2B in view of the original side rules and as per the CPC. These are my humble submissions. And Your Lordship, the affidavit, an affidavit we have said, Your Lordship, on 14th we have not received it, Your Lordship. That's my instructions.
14th you have not received.
Or if it is not received, at least Your Lordship.
But have you filed the rejoinder challenging this report?
No, rejoinder diye.
Have you filed the rejoinder challenging the report of the?
But at least the director has not, because I have to see the report.
No. With regard to service through postal service, the director out. Principal officer,
2A and 2B, Your Lordship, still there, Your Lordship.
Come.
Your Lordship, we have filed the rejoinder, Your Lordship.
File the rejoinder. Yes. Have you challenged that?
Yes, Your Lordship, we have said so. Lordship, paragraph F, Your Lordship, whatever Your Lordship I have written, rejoinder to the affidavit in reply, Your Lordship.
Yes.
Page 3, Your Lordship, paragraph F. I have stated, your lordship, in my reply.
And then I am calling the report
Yes.
from the.
Kindly
Yes,
call the report.
I think so. If it is written, your lordship, specifically, because it is mentioned, your lordship, in the service report, because service report has to be prepared on the basis of the.
I will call the report from the deputy office of the
Yes,
deputy.
my lord, how he has given this date of 14 November, he'll satisfy your lordship. If it's
He
there,
may,
it's there.
lordship, he may come with a track report. The reason
it.
is, no, not that's it. Your lordship, because today, your lordship, 22nd, because lordship, kindly appreciate, if the summon has been served, where is the occasion, your lordship, the personal service then? Then it's good. If it is served, it is served. Then why this particular bailiff is going on 22nd and giving me this particular? So I have my time will start, your lordship, on the later date.
Yeah, that is now the point.
Has to be.
The cat is out of the
What is
bag.
the use? What is the use of 14 that
Okay,
22nd?
let the report.
Yes, your
My
lordship.
lord,
Let
just
the report
one
come.
second, just to react to the new provisions which he has shown, I'll take half a second. My lord, my learned friend rightly points out, which I had also told your lordship, that 19A and 20A, he says, have been deleted. Kindly see what has been included. Kindly come to rule 9. Same order 5. This is general. This is general. 29A is specific. But kindly see rule 9, sub rule 3. The delivery of summons by court, kindly 3. The services of summons may be made by delivering or transmitting a copy thereof by registered post acknowledgement due addressed to the defendant or his agent empowered by to accept the service or by speed post. And the courier service is what your lordships have provided in the commercial direction. So registered post, speed post is always there under the code. That is why the commercial directions don't make any provision for it.
Yes.
Registered speed post is there in law. That is why commercial directions, practice directions framed by our code only deal with courier service, email, fax, etc. That is the logic. Your lordships are aware that this is already in the law. We don't have to make provision for this. Now, Melody shows your lordship the original side rules now in reply.
Yes.
Kindly see 24A. Kindly see 24A. 24 is not applicable. It applies to documents not being writ of summons. 24A has no applicability. It specifically says service of any notice, summons, order or other document not being writ of summons. Not being writ of summons, any other document which your lordship wants to be served, a rule which is issued under the Contempt Act.
Yes.
Any order for personal appearance, not being writ of summons.
So let the report first come.
Yeah, let
the
the
serving
report
of
come. I have no difficulty. If it has been served, then by post, that's the end.
Defendant has filed the present
that's not the
application.
end, your lordship. That is required to be adjudicated by the court. Your lordship, it's a
Defendant has
commercial
filed the
clue.
application
of the
being
day.
CA Coms 3 of 2025, praying for condoning the delay of filing return statement and for acceptance of the return statement. The plaintiff has relied upon the service report dated 10th February 2025, issued by the Deputy Sheriff of Calcutta, wherein it reveals that the writ of summons was served through the seal bailiff upon the defendant on 22nd November 2024 at 2:30 p.m. And the writ of summons sent by the Deputy Sheriff of Calcutta through postal authority was delivered to the addressee on 14/11/2024. 2024. Dono 24. Yeah. Learned counsel for the defendant has denied with regard to the service of writ of summons through the postal services on 14/11/2024. In view of the above, to adjudicate the matter, the report from the Deputy Sheriff of Calcutta is required to be filed before this court. Accordingly, the Deputy Sheriff of Calcutta is directed to place the record of service of writ of summons upon the defendant through postal services as well as through the bailiff of the present case on or before 11th of November 2025. Release the matter on 12th November 20.
Wait.
I'm grateful.
A copy service will be original. The registrar original side is directed to communicate this order to the bailiff and to the
Deputy Sheriff.
to the Deputy Sheriff of Calcutta for compliance.
Wait.
I'm grateful.
My lord, this is fine. My lord, I am for the defendant. I'm for the defendant, my lord.
Yes.
My lord would be required to frame the issues.
My lord,
My issues were handed over a long time ago.
my
I
lord,
believe.
may I indicate one thing, your lordship? First, also, we have not received the
You are appearing for whom?
for defendant, my lord.
Yes.
First, your lordship, we have not received for the suggested issues of the plaintiff, idiot, your lordship, not been served to us.
What?
Suggestive issues, your lordship.
Ah.
And second is, your lordship, that admission denial of the part of the copy of the admission denial of the plaintiff, your lordship, not been served to us.
Very well. That the second part
And my
is
lord,
possible.
our issue has already been submitted before the honor
Yes.
lordship. Lordship,
Have you filed the affidavit of admission?
yes, your
denial?
lordship. We have filed
Yes.
month of January, your lordship. And my lord, allow us to place the affidavit of documents.
Affidavit of?
Of documents, your lordship. That the formal procedure, your lordship.
You have taken inspection. So it all will be affidavit of.
Is there any counterclaim?
My lord,
There is no counterclaim, and this suit arises out of denial of payment in respect of an insurance claim. The facts are not really in dispute. The only thing is, he said there was contributory negligence, and therefore he has denied.
that is in terms of the insurance contract, your lord.
Very well, my lord. Even if my lord, the issues which I had suggested were only 2 or 3. If my lord can't find it, my lord can do it on this basis. Except issue number 1, 2, and 3, as my learned friend has suggested, is okay. Issue number 4 is assumed facts which have to be proved.
That has
My lord can just say, did the plaintiff breach general condition number 10? That's okay. Oh, cannot be done.
okay. Okay.
So your one is covered the one of the defendant.
Yes.
Correct. 2 you are not taken. 3 is okay.
My lord, I have kept it general. My lord,
Then the
if my lord wants to keep 2 and 3, I've got no objection.
then with regard to the 3, with regard to the 2,
Yes.
your 2 is covered in 4 of the defendant.
4 of the defendant, 4 of the defendant, my lord, cannot be worded like this. He has assumed facts here. Whether the act of the employee is sleeping in the upper berth, where is the proof of all this? This is to come.
Your case is that has been misplaced or whatever it may be.
That is the theft, and the theft is proved.
Theft.
The police have given a report. They've also accepted.
So why you are taking this sleeping under the berth? That is your case.
That is the case.
That you have to prove. Only with that, so I am taking the that 2.
My lord can reframe it as
My
did
lord,
the plaintiff
we
breach
don't need the issue on the facts.
No, that's why
This is a
taking the
matter of
two of the
fact.
plaintiff.
Yes.
I am taking the
Actually,
two of
we
the
do not
plaintiff.
have the copy of the issues framed by the
That point of time, they
plaintiff.
were not
That we
appearing.
couldn't. In fact, on 6th January, my lord, those issues and all were filed when they were not there. So this is a situation when plaintiff on number of occasions were not present.
Plaintiff has always been present.
No. I'm sorry. This is
Except on one date. Except
6th
on
January,
one date,
they were not there, my lord.
Exactly, except on one date. And I can show at least 10 dates when they were not there.
No.
The record will speak.
No,
Any
no,
case, that is
record
ni-
will speak.
That
I
is
have
neither
said
here nor
so.
there.
I have said so. I do not like to make any aspersion on that.
But the thing is, issues cannot be framed in this manner, where he says it facts. I mean, he's not going to the box to prove it. My lord,
Your 6. Whether the claim of raised by the plaintiff for this so and so along with the interest and interest upon judgment is required to be whether
That is their prayer. That is their prayer.
No, but that is not my prayer. My prayer is not my suit is dismissed.
No,
No.
The
So that is not my prayer. It would mislead.
No.
My lord will kindly frame
Just
it
let me
as
say,
if
or
the
you
pla-
say.
Is
No,
the
let
plaintiff
me
entitled
say.
to the release claim?
Okay.
If the
If
plaintiff
you
entitled
box
to
up all
release
the time, then
He says,
how
"This is
I'm
my
going
prayer."
to say?
he says, this is my prayer.
Let me
How can it be
say.
my prayer?
Let me say.
Yes.
Either you say or I say. We both cannot say at the same time.
Yes.
My lord, they have prayed for this amount along with the interest. So we have said that whether it is to be dismissed or not, that is our issue that we would like to frame.
So no, I am
Yes,
framing. I am
yes.
referring whether the claim made by the
Yes.
plaintiff with regard to principal
Yes,
amount
yes.
or the interest is entitled.
My lord, kindly take my rule from my 4, it will cover everything.
Yes. Record.
My lord,
Thousands of issues.
they may be directed to serve us a copy because we have served a copy.
And I don't have it here, but this
You
is
give-
But
suggested.
this,
Yeah,
every time this happens.
This is a suggested
Every time
This
this
is a
happens. They
suggestion
don't
being
come
made
with
to
a
the
copy.
Suggested is to be
Well, let him
acted.
see it if he wants.
No, why I would see in
Don't see.
this way.
Not to be
I
acted.
don't.
This is something
I
very.
don't have it here. This was filed a year ago.
Don't see, don't do this. This
It-
is
it-
not a court practice. What is
Give
this?
the copy.
Yes.
My
that's
lord,
what I want.
I will send it across to him. I will send it across to him.
The defendant has filed the
This is not
affidavit
to
of
appear and then-
document. Let the same be kept with the record. Both the parties have filed their suggested issues. And the learned counsel for the respective parties peruse the pleadings and the suggested issues. The following issues are framed. This 1, 2, 3, A4, 6, A5, 6 लिखो. Whether the plaintiff is entitled to get a decree with respect of the principal amount along with the interim interest and interest upon judgment at the rate of 18% per annum as prayed forward.
Man,
Okay.
if my admission denial, if my admission denial is not there, my lord will kindly allow me. I'll file it.
What?
The admission denial. He says.
Filed.
He says he's not got a copy. I'm not sure.
The
just now.
admission and denial नहीं है.
Everything else is done. Inspection has happened.
Video
everything.
admission denial.
His
for
admission
defendant.
denial is there. My one, I'll just
Lord,
check it.
we have filed it on 6th January
Yours is
2020.
there.
Yes. I'm not disputing that. I'm saying
They
if
have neither served the copy nor we.
Why you are not serving the copy and all these things?
Yes, they are
I will
not
not
served.
serve.
my lord, this as
This habit is there.
they were not appearing.
नहीं.
I don't say like this.
otherwise
I'm
how
not
did-
appearing. Even yesterday when the matter came up, you didn't appear.
Yes, because we're not supposed to.
Yes. Don't say that.
The plaintiff is directed to
How
file
the court
the
get into it?
affidavit of admission and deny the document within a week from date after serving
My
the
lord.
copy to the learned counsel for the defendant. The plaintiff is also directed to file the judge's brief of document within
Right.
4 weeks from date. Full stop. Affidavit of evidence of the plaintiff witness be filed within 2 weeks thereafter. After serving the copy to the learned counsel for the defendant, let the matter appear on, give the date, 12th January at 2 p.m. for witness action.
Grateful.
Would it be my lord's pleasure to? It will not take much. Would it be my lord's pleasure to fix a time?
2 p.m.
2 p.m.
Witness action 2 p.m.
না
ডকুমেন্টস ডকুমেন্টস আমাদের ফাইল হয়ে গেছে
না না ফাইল করতে বলেছে তোমাকে
Next.
না ডিফেন্ডে কোনো বলে বাদ বাকি কথা বলছো I'm praying for
not today, my why?
because my senior he is suffering high fever.
High fever.
That's why I'm praying for not today.
On the last occasion also you have taken time. Aryan Chakravarti is appearing for the plaintiff. Press for time according to case adjourned. What steps you have to be taken?
I have no
Press
instruction.
for time for taking appropriate steps. 2019 suit. Anybody is appearing? Defendant?
No.
Writ of summons has not been served and you are not taken. I am dismissing. Report has come in March 2025. Writ of summons has not been served upon any of the defendants. On defendant, but you not taken a step on the last occasion. Your senior has taken time.
Last chance, my lord.
It is fine from the record. It is fine from the report submitted by the Registrar of Original Site dated 5th of March 2025. Writ of summons was not served upon the defendant till date. Full stop. On 4th of April 2025, 28th of April 2025, Learned Counsel for the plaintiff has prayed for time for taking appropriate steps. When the matter is taken up today, Learned Counsel for the plaintiff prays for time. For the interest of justice, the case is adjourned. It is made clear that by the next date fixed, the plaintiff failed to take appropriate step for issuance of fresh writ of summons upon the defendant, the suit will be dismissed. Let the matter appear on 19th of November 2025 under the heading order. Yes.
My lord, we are for the plaintiff, my lord. We are seeking leave, my lord. Our plaintiff's name has been amended, my lord, according as per the ROC, my lord. My lord, this was the last order, my lord. My lord, pursuant to the last order, we were supposed to serve a copy of the plaint to the defendants. The name of the defendants have also been amended, and as well as the plaintiffs.
I'm for the defendant.
I'm seeking your kind leave to file an amendment application to change the name of the plaintiff, my lord.
Amended copy of the plaint.
The defendant's name has changed from defendant number 1 to 1A, my lord.
Huh? Yes, have you served the amended copy?
My lord, we were unable to serve the amended copy because the name of the plaintiff has also changed, my lord. So I'm seeking your kind leave, my lord, to make an amendment application to change the name
When
of
it
the
was
plaintiff.
changed? When the plaintiff's name has been changed?
My lord, it was changed sometime around in, my lord, in April.
And June order was passed on that day. You are not
My lord,
mentioned.
we didn't have any instructions.
So if you're not having instruction, why you persons are appearing? If the April the name has changed, June there was an order.
My lord, kindly will grant a leave.
Counsel for the defendant submitted, in spite of the order passed by this court dated 17 June 2025, the plaintiff has not served the amended copy of the plaint to the defendant. number 1A. Defendant number 1A. Police. Counsel for the defendant plaintiff submit that the name of the plaintiff company has also been changed, and as such, the amended copy of the plaint has not been served upon the counsel for the defendant number 1A. And he prays for time for taking appropriate steps for correction of the name of the plaintiff. In view of the submission made by the counsel for the plaintiff, the case is adjourned. Let the matter appear on 25th of November 2025.
नाम के correction
Next.
I'm grateful, my lord.
Well, my lord, I'm appearing for the plaintiffs in this matter. Lord, on the last occasion, we had produced a copy of e-publication of newspapers to show that the plaintiffs had complied with the direction for substituted service of summons on defendant number 2, 8, 9, and 10. And my lord had directed that the copy be filed by way of affidavit and a report be obtained from the department that whether defendant number 2, 8, 9, and 10 have entered appearance or file any written statement or not.
Lordship, I am appearing for the defendant number 6, HDFC Bank in this matter. My lord, I'm at the outset, I must tender my apologies. My lord, this is another suit. Similar suit appeared in the Lordship list on Tuesday, where my lord, I had indicated that we have filed an application in Order 7, Rule 11 for rejection of the plaint. And I had also pointed out that I have filed an application wherein an order was passed by this honorable court in 2019 that the suit will not be transferred to the undefended list. In this is a similar type of suit, but not the same suit, but similar grounds are there. Here also we have filed an application under Order 7, Rule 11, which is GA number 6 of 2000, new GA 6 of 2019. My lord, unfortunately, I've tendered my apologies on the last day when the Lordship had taken up this matter. My lord, that day, my lord, I had no instructions to appear. I am for the bank, my lord, obviously the bank, I don't know for what reasons, my lord, they didn't instruct us to appear on the last day. That is, my lord, on that day, Lordship had passed an order saying that Lordship wanted to know who were appearing and who are not appearing.
Where is that? Where is the affidavit of e-copy of the paper publication?
This is the affidavit, my lord. And we have obtained report, my lord. Defendant number 2, 8, and 9, and 10 have not entered appearance.
Yes. Mr. Sharma, you are appearing for?
HDFC Bank, defendant number 6.
One, 3, 5, 7, and 11 have not entered appearance either in person. Defendant number 2, 8, 9 have not entered appearance either. So 1, 2, 3, 5, 7, 8, 9, 10, and 11 not entered appearance.
My lord, kindly seize order dated 24th March 2025. It was passed by a coordinate bench, my lord.
Contains the copy and thing, didn't it? Defendant number have not filed written in all the summon has been served. The petitioner is undefended 1, then 2. Where is the 2? 1, 3, 5, 6, 7, 11, and 12. 6 also undefended.
My lord, 6, my lord, there's an order of 5th. If in this matter, there's an order whereby the suit will not be transferred to the undefended list. When I moved my Order 7, Rule 11, that order is dated April 5, 2019.
So, but on 24th of March, the court has passed an order for undefended.
Yes, my lord. That is why I was tendering my apologies, my lord. And that is, I was tendering my apology, my lord. The bank did not instruct us to appear on the last date, and that is.
Let the bank be remain undefended. What can be done?
Lordship, this prayer, Mala, I made this. May I just have a last opportunity? On Tuesday, Mala, Lordship had considered my prayer in the other suit and has kept it in the month of November. And
This court has to go by the order. No, this order.
Same orders were there in the other suit also, my lord. In that suit also, bank was not represented on the last day in June 2025, and Lordship had shown some mercy on my client, my lord.
Whatever, no, but now I am not in mercy.
Kindly give me one last chance, my lord.
For once, not the twice or thrice.
Once we did not appear, I think.
Cannot be a right.
No. Only, Mala, I was praying, Mala, kindly keep the matter sometime next week. I will come and argue my GA A6.
Consequences. Let the bank face consequences.
Mala, public.
To the leniency to the other persons. If
No. Mala, there was an order already. My lordship kindly considers that, Mala. We had obtained an order in.
Bank is giving the leniency to the general public.
Kindly consider this, man. I was making humble prayer. I leave it upon my Lord.
That is the problem. You persons are not appearing. The court is passing on order. Subsequently, you are coming. This was the order. Court has not considered. And making the allegation before the appellate court, the court, in spite of the order, passed this order.
No, man. That we never make such allegation.
Not you are making any application. You are not time to file an application for recalling of the order. Take it granted that the court will take the lenience and will pass an order.
I appreciate.
Counsel for the defendant has filed affidavit of service.
Counsel for plaintiff, my lord.
Counsel for the plaintiff has filed affidavit of service, enclosing the newspaper showing that the paper publication was made for service of writ of summons upon the defendant. The plaintiff has also handed over the service report issued by the issued by the deputy registrar within bracket legal dated 14th May 2025, wherein it reveals that the defendant number 1, 2, 3, 5, 7, 2, 3, 5, 7, 8, 9, 10, and 11 have neither entered appearance nor have filed the written statement. This court finds that by an order dated 24th of March 2025, this court has already placed the matter in the undefended suit against the defendant number 1, 3, 5, 6, 7, and 11. 7 and 11. Learned counsel appearing for the defendant number 6, HDFC Bank, submits that there is an order. By which order? Where is our order?
My order date is 5th April 2019, passed in my application of the coordinated bench. April 5, 2019, passed in old GA 888 of 2019, which is now new GA 6 of 2019.
Order here.
That is annexed to my affidavit in opposition in GA 8. GA 8 is an application filed by defendant number 2 AB and Amro Bank, wherein I filed my opposition dated 29 July 2021, wherein this new GA 8 of 2021. In that opposition, I have annexed this order, my lord. Page 13, 1-3. Opposition of Debojyoti Palit, dated July 29, 2021.
Where is the order?
Page 1-3, I think. Lordship has found the opposition, page 1-3, annexure A.
क्या बोला? Against 6. has drawn the attention of this court to the order dated 5th April 2019 in GA number 888 of 2019. 888 is now GA 8.
Yes, my lord.
Yes, my lord. New G8 of 19.
New GA 8 of 2021, wherein this court has an order.
My lord, I think the GS6, my lord. I'm sorry. GS6 of 19.
888 of 2019, wherein this court has directed not to transfer the suit in the list of undefendant against the defendant number 6. Defendant number 6 till the disposal of the above application. GA number 888 of 2019. In view of the above, the order dated 24th of March 2025, 24th March 2025 is modified only to the extent by not treating the undefendant, not treating as undefendant against the defendant number 6. Yes, how many GAs are pending?
2 GS, my lord.
What are the
One is
GAs?
the application filed by my learned friend, and another application is filed by defendant number 2, I think.
2.
Saying
What are the applications?
GA number 6.
6 and G8, my lord. 6 and 8.
What are the applications?
GA number 8 is application by defendant number 2, saying that the suit can be decreed in terms of the prayers of the plaint, my lord. And we are saying that
about this 6.
6 is the demurrer application of my learned friend.
It is submitted by the learned counsel for the plaintiff. There are 2 applications are pending. Pleadings completed.
Yes, ma'am.
In which the pleadings have been completed. Let both the application be placed for hearing on 26th of November 2025.
Grateful, lordship.
A copy of that. Okay.
Yes, my lord, it has changed. I've just seen the notification. Lordship is now in group 9, my lord. Residuary. We are more very heavy, most heaviest bench, my lord. Heavy determination. I was just going through it. We just got 10 minutes ago, my lord.
Yes. Residuary.
Group, very heavy bench, my lord. And the most important thing was the courtrooms are always full, not a space to keep a leg also. Courtrooms are full, group 9.
My lord, in this matter, since defendant number 2, 8, 9, and 10 have not entered appearance, I think the suit can be placed undefended as a grateful, my lord. Perhaps, my lord, today the direction for
today No, not talking. This is subsequent report.
my lord, the grateful, my lord.
May it please your lordship, I am appearing on behalf of the plaintiff in this matter. Lord, talks of settlement are going on between the plaintiff and the defendant. In view of that, your lordship kindly keeps adjourns the matter for a month or so. Lordship is not audible, my lord. I can't hear, my lord.
You are for the plaintiff?
I'm for the plaintiff, your lordship.
Counsel for the plaintiff submitted. The talk of settlement between the parties is going on. Accordingly, praise for time. In view of the submission made by the counsel for the case adjourned, let the matter appear in the combined monthly list of December 2012. 2020.
Extremely grateful. Extremely grateful.
Yes, next.
That I appear for the plaintiff, my lord.
Number 14.
This suit was transferred from original side to commercial division, my lord. I have already taken steps, my lord. On the last occasion, the defendant paid for time to take the appropriate steps for compliance with the provisions of the
Yes.
Commercial Courts Act. I don't think, my lord.
Yes, sir. Your Lordship, I appear for the defendant, Your Lordship. On the last occasion, we were directed to comply with the steps, my lord, but due to some difficulty on our part, it has not been done yet. So, my lord, I just pray before Lordship for 2 weeks' time, my lord. In the interim, my lord, we will be able to do the necessary compliances. Kindly, it may be granted with a
Persons in the commercial suit, every time you are taking the time, why the commercial court has been amended, the commercial act has come into force. For expedite. Counsel for the defendant prays for time to take appropriate steps for compliance of the provisions of the Commercial Court Act. In view of the submission made by the counsel for the defendant, case adjourned. The defendant directed to comply with the provisions of the Commercial Court Act within a period of 2 weeks. Release the matter on 25th of November 2020.
Deeply.
Minute 15. I am for the respondent. There is GA2, my lord. They have filed, my lord, for summary judgment under, my lord, Chapter 13A. That perhaps, my lord, has become infructuous because the only ground taken in that application is that I have not filed any written statement. But the day the application is affirmed, my lord, 2 days after that, my lord, the order was passed, my lord, allowing me to file written statement, and I have already filed that. It is, may I just show that, my lord, then if your lordship, my lord, is
Which
satisfied.
for the plaintiff?
Plaintiff, my lord. Advocate on record is Miss R. Goel.
Mr. Rashid.
Ishika Goel. And
Not today. Not today.
and then, my lord, can you record it, my lord, that they are not present and on
As none appears on behalf of the plaintiff. According case adjourned, let the matter appear on 11th November.
well, nah, kindly not use that word adjourned because then the matter is kept on 11.
None appears on behalf for the
Because
interest of
when it's
justice.
adjourned, then it all becomes ineffective for us.
Okay, none appears on behalf of the plaintiff. Let the matter appear on 11th.
Grateful.
My lord, I appear for the plaintiff in this matter. Item number 16.
Yes.
My lord, on the last occasion, my lord had called for a report from the registrar regarding service of the issuance of the writ of summons. There was some discrepancy. I had a report which said that the writ of summons was lodged.
ये रिपोर्ट आया है क्या? So where is the report dated 31st of January 2014? That is the correct report.
My lord, then the writ of summons was issued. The plaint was served upon the defendant, my lord. Until date, they have not filed their written statement, my lord.
So you are for the plaintiff.
I am for the plaintiff.
How many defendants are there?
My lord, only one defendant, my lord. For all along, the defendant has not appeared in the matter. My lord.
Two defendants.
Sorry, my lord, two defendants.
In terms of the order dated 16 June 2025, the registrar original side has submitted report dated 21st of June 2025, wherein it reveals that the report dated 31st of January 2014 issued by the office of the Deputy Sheriff regarding the service of summons of CS Com 814 of 2014 within bracket old CS 58 of 2011 is correct. Correct. And the second report dated 16 January 2025 issued by the office sheriff is not reflect the true state of affairs as per the record maintained by the office of the deputy sheriff. In view of the above, the report dated 31st of January 2014 is accepted. It is fine from the report that the writ of summons has been served upon the defendants on 16th of January 2014, but in spite of receipt of writ of summons, none appears on behalf of the defendants. In view of the above, CS Com 814 of 2024 within bracket old CS 58 of 2011 be placed in the list of undefendant suit. The plaintiff is directed to file the judge's brief or document within
4 weeks.
Within 4 weeks. Affidavit of evidence of the plaintiff witness be filed within 2 weeks thereafter. This is the matter for witness action on 12 January 2025 at 3 p.m.
Grateful, my lord.
Next. 26. Yes, next.
Your Lordship, in this matter, the writ of summons was served on 8th of January 2025. 120 days are over and no one has filed the written statement.
Have you obtained report?
Your Lordship, I have. Your Lordship, this is the service report. It must be there in the file.
The plaintiff has filed the service report dated 17 February 2025, wherein it reveals that writ of summons was served upon the defendant through bailiff on 21st of January 2025 and through the postal authorities on 10th of January 2025. 2025, full stop. The Learned Counsel for the plaintiff has also handed over the report issued by the Deputy Registrar within bracket legal dated 19th May 2025, wherein it reveals that none appears on the defendant has not entered appearance either in person or through the advocate. In view of the above, let the reports be kept in the record. In view of the above, TS Com 815/2024 be placed in the list of undefendant suit. The plaintiff is directed to file the judge's brief of document within 3 weeks. 3 weeks. Within 3 weeks. Please the matter.
Your Lordship, the affidavit of evidence. The affidavit of evidence.
3 weeks, affidavit of evidence be filed within a week thereafter.
Your Lordship, 2 weeks thereafter.
2 weeks thereafter. This is the matter for witness action. Next.
Your Lordship, I appear on behalf of the plaintiff, Your Lordship. On the last occasion when the matter was taken up, Your Lordship, on June 16th, Your Lordship was pleased to direct the department to provide a copy of the written statement, Your Lordship.
No affidavit of competency following defects of point and scrutiny of the defendant. Who is for the defendant? They have filed the written statement, but there are defects.
Yes, Your Lordship.
There are defects. No affidavit of competency. Typographical error in paragraph 2 at page 12. Correction verification at page 11. Require authorization. So, written statement is not accepted. What can be done? Written statement filed in the year 2009.
We have served them notices also, Your Lordship, as per Lordship's direction, but no one is appearing, Your Lordship. I'm being led by Mr. Sharathi Dasgupta, Your Lordship. I'm humbly praying the matter can be fixed any day, Your Lordship.
The section officer attached to the office of the London Master and official referee has filed a report dated 19th June 2025, wherein it reveals that the written statement filed by the defendant wherein it reveals that there are several defects in the written statement filed by the defendant, but the defendant has not rectified the same till date. In view of the above, for the interest of justice, the case is adjourned. The defendant is directed to rectify the defects as pointed out by the department within 2 weeks from date. List the matter on 19th of November 2025.
Obliged.
Item 19.
Next bench.
Milad, this is Milad, 1 second matter, Milad.
What?
Milad, I appear for the defendant. Milad, it has been transferred to Milad the commercial court. Milad, they have.
On behalf of the.
Yes. Then let him submit, Milad. It has been transferred, Milad. We have received the Milad
It has
documents.
been to the commercial division. Today was the issues have.
Commercial court.
Yes. We have also served it upon the defendants.
Yes, complied with Mr.
Very well, Milad. Milad will pass necessary orders, Milad. The written statement was, I think, earlier filed. Yes, yes, it was. Yes, it was filed earlier, Milad.
Taken the steps for rectification of that compliance of the commercial court.
No, perhaps that has not been done, Milad. No. We'll take steps, Milad. We'll take steps, Milad, in accordingly, Milad.
2 weeks time.
Milad, that Milad, Mr. Mitra is then Milad, 2 weeks is over.
Milad. On the last occasion, my lord kindly grants me 4 weeks time. I shall comply with everything. My lord, issues have already been filed. Pre-transfer.
Yes. Pre-transfer.
Amendment is to be carried out.
Yes, my lord. I bow down. My lord, only problem is my client, my lord, he is based in Bangalore. My lord, I do not want to commit any failure. That is why I am
2 hours journey.
He was Milad 4 weeks, Milad.
Kindly grants me 4 weeks, my lord. Let them
He was 4 weeks.
In January.
Yes.
The counsel for the plaintiff submitted after transfer of the suit from the non-commercial suit, the plaintiff has carried out the provision. Counsel for the defendant. The Commercial Court Act and placed for 4 weeks time. In view of the submission made by the counsel for the defendant is granted 4 weeks time to comply with the provisions of the Commercial Court Act in the written statement. Let the matter appear on 4th December.
Obliged.
Yes,
Milad is now getting a huge determination.
Don't know. I have not seen.
Group 9.
Oh.
Group 9. Milad will not find Milad no time, and Milad was not having any time this side also. Milad in this determination. Milad group 9. Both original side and appellate side.
My lord, item number 20, very short direction.
Obliged.
Statement filed by defendant after paying costs, they have complied with it. My lord, direction for inspection, admission, denial, and suggested issue. 20, item number 20.
It is fine from the record. The defendant has already filed the written statement. The parties are directed to complete the discovery and inspection of the document within 3 weeks. Within 3 weeks.
4 weeks. My client is outside, not so.
You are not within 4 weeks.
Dependent.
Within 4 weeks. Affidavit of admission and denial be filed within 2 weeks thereafter. In the meantime, the parties are also directed to exchange the suggested issues. List the matter. 4 weeks, 2 weeks, 6 weeks. Na? List the matter on 4th of December 6 weeks. 11th of December 2025 for framing of issues.
I'm extremely grateful to madam.
Now I'll have to take a chance before the other bench. Mornings.
Huh?
Mornings mentioning, Lord, now I'll have to take a chance before the other bench.
You saved.
I'm not sure, my lord. I'm not sure.
Lord, I appear on behalf of the plaintiffs, my lord. I had concluded my submissions on the last day. Lord, I have a very humble prayer before your lordship. Your lordship has heard me in full. My learned friend today, my lord, will, my lord, substantially, my lord, conclude his, my lord, may I request, my lord, for, my lord, this matter to be marked as part of, my lord, today, my learned friend will.
See, today's my file, all especially, how many matters in the origin that non-commercial division? 50. All assignment. I don't know how the group 9 along with this assignment will take.
Group 9 is a hefty determination.
I don't think.
Will manage.
Very
Lord,
difficult.
only this, my lord, this matter, my lord, I've concluded. Lord, my learned friend will today by 150.
What is the matter?
My lord, recovery of money, my lord, 1.63 crores, which was paid, admittedly. My lord, thereafter, a check.
No admission.
My lord, check has been issued.
He has admitted, you are not in.
Check has been issued, my lord. On the basis of that check, my lord, 138 proceedings have been filed in the course of cross-examination, my lord, and in particular question 83. My lord, my learned friend has admitted that money has been received, but he is not paid it. My lord, that has come out in the cross-examination as well. My lord, and my lord, also, my lord, lordship will also take note of the fact, my lord, in response to the legal argument which has been thrown by my learned friend, saying that this is unregistered, my lord, I had relied upon the proviso to section 49, which says for collateral purposes. And my lord, I had also represented, my lord, that I had, my lord, filed the, my lord, the memorandum of understanding. My lord, that memorandum of understanding I had filed only for the purpose of compliance with my lord, Commercial Courts Act, which asks for full disclosure of the entire, all the documents, my lord, and to establish the jural relation. My lord, I am not asking your lordship to consider any particular clause and grant me a decree, because my lord, the payment of money and the admission by the defendant, my lord, is sufficient in my most respectful submission for me to be granted a decree in my favor. And insofar as my lord, limitation was concerned, my lord, I had represented to your lordship that it is within the period of 3 years. My lord, under section 18 of the Limitation Act, and in the alternative, my lord, I had relied upon section 25(3) of the, my lord, Indian Contract Act to say that there is a promise to pay on the basis of a check which has been issued, which has been signed. My lord, these are my submissions. My lord, only one submission which I have not dealt with is my learned friends have taken the point that, my lord, pre-suit mediation, my lord, ought to have been done. My lord, to which my response was, my lord, paragraph 90 of Lakshmi Polyfab, which says if a suit is instituted prior to 11 December 2020, Lord, compliant, because the mechanism for pre-suit mediation only came in thereafter. Lord, these were my respectful submissions. Lord, my learned friend can start. Grateful.
Lord, only one.
Why before the other bench?
Lord, lordship has heard.
Start only with a caveat, my lord. If your lordship kindly keeps it part-heard, otherwise the entire exercise will be futile.
Joint prayer.
Entire exercise will be futile because I will take some time, my lord. Today may not be possible, my lord. I can start. I am ready with the matter. But my lord, if your lordship kindly keeps it parted, then I can start.
Yes.
I don't know. I have not seen, but under the group 9, how the parted matter of the original will
one
is very difficult. It's a hefty
kindly
determination.
I don't think so. The group 9 has. Yes. We will continue today.
Lord, lordship kindly keeps it parted then, my lord. Otherwise, my lord, entire exercise will be futile.
Counsel for the plaintiff has already concluded the argument. Please. Counsel for the defendant has argued the matter at length, but he prays for time. Accordingly, case is adjourned. Let the matter appear on 12th November as parted.
Grateful, Lord.
So
Deeply
grateful,
obliged,
Your
Lord.
Lordship. Your Lordship was not hearing us today.
Lord, Lord, today, 12th of November, I have some personal difficulty. If your Lordship kindly keeps it, Lord.
14th November?
Grateful, Lord. Deeply obliged.
Yes, next.
Lordship, I am appearing on behalf of the plaintiff.
I appear on behalf of the defendant, my lord, pursuant to the direction of the order dated 20th of May, we had already filed the written statement. Leave was granted, my lord, beyond
No copy has been served yet.
that we will
Granted, accepted.
No, it was accepted.
Accepted by
Is my instruction, my lord. Yes, my lord, coordinate bench, my lord. This is an order of 20th May.
20 May?
Yes, my lord. The order to the. But may I hand over a copy of the order? The urgent determination was with Justice Kapoor.
Yes. Serve the copy.
We will serve a copy.
There is no counterclaim.
No, my lord.
There's any counterclaim?
No.
So you serve the copy and passing a direction for inspection, discovery inspection?
Right.
Not sure. It is fine from the record. The defendant has already filed written statement. The defendant is directed to serve the copy of the written statement to the plaintiff in course of the day. The parties are directed to complete the discovery and inspection of the document. Complete the discovery and inspection of the document within 3 weeks.
3 weeks.
Within 3 weeks. The parties are also directed to file their affidavit of admission and denial of the document within 2 weeks thereafter. In the meantime, the parties are also directed. The parties are directed to exchange their suggested issues. 3 weeks, 2 weeks, 5 weeks. List the matter on 17th December for framing of issues.
Item 22 is also a similar matter, same date order.
Same
order.
Same order 22. Next.
I am appearing, Lordship, in this matter on behalf of the plaintiff.
I appear for the defendant, Milord. Milord, on the last occasion, Milord, we have filed our written statement within 30 days of time, Milord. They disputed that, Milord. Your Lordship directed, Milord, to place the, Milord, the written statement on record by the department, Milord. We have received and we have filed it on 21st of April, Milord, within the 30 days time, Milord, from the date of receipt.
Accepted?
Milord, since it was within 30 days, Milord, it was accepted by the department, but they are disputing that.
You are the defendant?
Yes.
Yes. What is the dispute?
Okay, Lordship.
Accepted?
Yes, Lord.
Same order? Same discovery and inspection?
Yes.
3 weeks, 2 weeks, 17, 17 December for framing of issues.
Right.
I'm grateful to
record that the written statement has come because it was not there on the last time.
Defendant already filed the written statement. Defendants already filed the written statement. Parties are directed to complete the discovery and inspection. Next. $24. नहीं है कोई. Not today.
This is my suit, the Lordship. I appear for the plaintiff. On the last occasion, my lord, the defendant had appeared and said and sought time to file the written statement. I'm just handing up the last order. Till date, my lord, we have not been served with any copy of any written statement.
No return statement is filed.
Not been served.
You obtain report from the department. Then the undefended suit it will go. Otherwise, it might be in the department.
Yes, Lordship, but
Have
they
you
have not
checked the
served me.
department?
They have not served me with it.
None appears on behalf of the defendant. Counsel for the plaintiff submit that the defendant has entered appearance and taken time from this court for filing written statement, but till date no written statement has been served. In view of the above, the plaintiff is directed to obtain report from the department to ascertain whether the defendant has filed written statement or not. This is the matter on 13th November 2025. Yes, next.
26, Your Lordship, I am for the plaintiff in this matter.
You are appearing in the original side, suit.
Yes, I am for the plaintiff. This is a change brief, Your Lordship, and in this matter, interlocutory application has not been filed. I am paying 3 weeks time to file interlocutory application in connection of this suit, Your Lordship.
For what?
For my grievance, Your Lordship, because and another one thing, my lord, the writ of summons has been served on earlier occasion in the month of March 2025, but that has not been delivered. And I have collected the report from the department, and that report shows that the writ of summons has not been delivered. So I am praying for another service of writ of summons.
Counsel for the plaintiff submit that though the plaintiff has taken steps for issuance of lodging writ of summons, but writ of summons could not be served upon the defendant. Accordingly, prays for time for taking fresh steps for lodging fresh writ of summons upon the defendants. In view of the submission made by the counsel for the plaintiff is directed to take appropriate step for lodging fresh writ of summons for service upon the defendant within 2 weeks from date.
Grateful.
Hey, parties, hey. Yes, both the parties are there in any suit. Nobody is interested to go to the.
Item number 37, my lord.
Yes.
I am for the plaintiff, my lord.
Hmm.
An application under order 13A has been taken out by the plaintiff, my lord. 13A, order 13A.
Yes.
My lord, claim on account of goods sold and delivered, my lord. My lord, defendant number 1 is not contesting, my lord. And my lord, defendant number 2 has entered appearance and filed the written statement, my lord, and had admitted the fact that the goods have been supplied to defendant number 1.
So what?
So, my lord, this application is appearing for the first time, my lord. So, my lord,
Where is the defendant?
defendants are not.
So what can be done? Let they come.
My lord.
If they have appeared, both the parties are ready, I will take the matter, no problem. If any matter, both the parties are ready.
Item 32, my lord, there was a previous direction for my lord.
32?
Yes, my lord.
Yes.
Winnie Fabrics, my lord, there was a previous direction for my lord paper publication, which we have complied with, my lord.
Have you obtained report? Any person entered appearance?
No one has entered appearance, but that report perhaps was before the paper publication. So
Subsequent to paper.
yes, let me this
Obtained
be
report.
taken on
I am
record.
taking on record.
Yes, my lord. In the meantime, we will.
Item number 32.
Yes, my lord. Winnie Fabrics versus Karikanath Silks.
Record and
Karikanath.
In compliance of the order dated 18 September 2025, the plaintiff has published the notice in the English newspaper.
Yes, ma'am. In newspaper में जाएगा तो.
English and Hindi. In the English and Malayalam newspaper. And file the affidavit of service enclosing the copy of the newspaper publication. Let the same be kept with the record. Counsel for the plaintiff prays for time to obtain report from the department to ascertain whether the defendants have entered appearance or not.
A week's time, my lord, thereafter.
In view of the submission made by the counsel for the plaintiff, the case adjourned. Let the matter appear on 10th of November.
Deep leverage.
Yes.
Lordship, item 33, your lordship. I am for the respondent. The suit has been settled. Only thing that we have to make certain payment. So if it can be listed after on 10th of November, then we can file the terms of settlement.
33 record. You are for the plaintiff.
I am for the defendant. I am for the defendant. It has been settled. There are appeals also. There also we have made the similar prayer.
The matter has been settled between the parties and prayed for fixing the matter on 10th of November 2025. In view of the submission made by the counsel for the defendant, let the matter appear on 10th of November.
DPO.
9:30, my lord. 9:30 is not called. Yeah, we start with the next. Yes. That was kept at 1 p.m. for extension of interim order. The interim order is expiring today. Right? Yes, yes, yes. Who is for the other side? Well, the other side we've served. It was an ex parte ad interim. We've served the notice thrice. Bank will not possibly appear because the bank, even when we were moving it during the vacation bench, we are intimated the bank did not appear. The matter is mentioned by the learned advocate appearing for the plaintiff and submit that the interim order is still today and paid for extension of interim order. He submits that the notice have been issued to the defendant but none appears on behalf of the defendant. In view of the above, the interim order dated 16th October 2025 is extended till 20 November 2025. You are appearing?
Yes, sir. No, I'm it is not in here.
No.
Oh, I'm so sorry.
20th November 2025 or until further order, whichever is earlier. यहाँ नहीं है लिस्ट नहीं प्रोडक्शन
This is where I am appearing for the petitioner.
For the alleged contempt number 13, may I file the opposition, my lord?
Kindly looks at the order of 12th September 2025.
Yes.
Passed by your lordship.
Have you filed the affidavit in opposition?
Yes, my lord, I mentioned it, my lord. That was
Reply
on
to
my part.
13 and reply to the info to the winner.
It was affirmed on 9th, but on 12th.
You are appearing for whom?
Alleged contempt number 13.
13. What about the 8, 9, 10 and 11?
They have not filed.
They have not filed.
My lord, we are appearing for 1 to 6.
Go one by one. 8, 9, 10, 11, my lord.
Hmm.
My lord, they have Mrs. Ujani Chatterjee was appearing. They have not filed their affidavit. So, my lord, I was praying for issuance of warrant of arrest. As far as 1 to 6,
let first 1 to 6, you are appearing.
They are appearing. They were supposed to be already a warrant of arrest had been issued.
Affidavit is filed.
My lord, we are seeking 1 week's time to
for
file.
what?
To file our affidavit, my lord. 1 week.
Already arrest warrant is issued.
Warrant has already been issued.
My lord, they are present in the court.
Where?
Not all.
No, not all.
All of them are.
1 to 6.
Yes, my lord.
Where are they?
You have been brought.
They are outside the court, my lord. We are calling them.
Bring.
Why is the
So why you are waiting for the warrant?
and why are the police not producing them?
And why? How they are surrendering or they have been produced by the police?
They have been produced by the police.
Where is the report of the police? Who has produced? शरीफ के इसको जमा नहीं किया है वारंट में लाया दिया रिपोर्ट आया
প্রোডাকশন করছে কিন্তু প্রোডাকশন করছেন তো জিজ্ঞেস করছেন কি এনেছেন ওনাদেরকে
Only two persons. Only 2 persons.
How many persons have been arrested?
Only 2.
And 4 others are present, my lord.
So how they were present?
My lord, we came to know about the order, so just to comply with the order, they are present in the court, my lord.
How it can be taken into consideration? Who will identify? Who will identify?
My lord, they have brought their Aadhaar card with them.
1, 2, 5 and 6 could not be found in the mention. They are not residing in the address which they have provided.
They are.
So where there is a report.
Managed naturally.
What is the name? The person who have been arrested?
Mohammad Arif.
Mohammad Arif and?
Yes,
Mohammad Tariq. These 2 persons have been arrested. Mohammad Arif and Mohammad Tariq are
My lord, they are, my lord. 3 and 4. Respondent containment number 3 and 4.
Yes. And 1, 2, 5 and 6.
They are present in the court, my lord.
They have now today present in court, but I suppose the report says they are not residing
Yes,
at their
they're not
address.
residing in.
Very,
they
very,
will-
my lord, surprising.
So tomorrow, if today I will release them, tomorrow again they will flee away from
They
the
will
court.
appear, my lord.
How? Have you filed the wakalatnama?
My lord.
When?
On 4th September, my lord.
So why you not appeared on the last occasion?
My lord, I was stuck in some other court and the list suddenly collapsed, my lord. That is why I could not appear, my lord. By the time I reached court, my lord, the item number 24 was going on.
Okay.
Ours was item number 21.
Okay, then what about the 6, 7, 8?
My lord, 8 to 11, my lord, I am representing, my lord, and this is my affidavit in opposition. And my lord, I am serving a copy also, my lord, upon the
Give the copy.
petitioner, my lord.
8, 10, 8, 9, 10, 11.
Yes,
8, 9, 10, 11.
my lord, 10 and 11 is present in court also, my lord.
Okay, what about the 7 and 12?
7 and 12.
Where is your affidavit? Already filed. Have you received Mr. Ghosh?
Reply.
No, 7 and
Yes, yes, reply is also ready. I'm filing in.
Okay. So remaining?
So, my lord, 8, 9, 10, 11, that group, and my lord, 1 to
13.
6.
You are for the 13.
13 has filed today. আমাদের reply to 13.
Have you saw the copy?
Yes. 13 has a reply also, my lord, filed by court.
So you filed the reply on behalf of for the
Petitioner.
8, 9, 10, 11.
No, 8, 9, 10, 11 is just given today.
So you filed with regard to 7 and 12. 7 and 12 not filed.
7,
7 and 12 you filed.
7, 12 reply I have filed and 13 reply I have filed today.
Okay. 13. 7, 12 and 13.
13. Yes.
So you want to file the reply with regard to 8, 9, 10, 11.
8, 9, 10, 11, which has been
What
given
about the
today.
1 to 6? You are appearing for all.
1 to 6, my lord.
Yes, what is your submission?
My lord, I would take 1 week's time to file my affidavit, my lord. And we are also taking out an application seeking modification of the order.
After violation.
Yeah,
My lord, a copy may be served upon you.
But give the copy.
Reply copy to the my lord, I shall give it in the course of.
Alleged content number 2 and 3. We have brought an arrest by the police of.
Excuse me, my lord. I am plaintiff's son. The original order was passed in the last year, and since then, more than 1 year has gone by, and these contemners 1 to 6 have not complied with your orders. And there were 4 directions in your order. They had to submit annual quarterly accounts, and they had to pay monthly maintenance payment. And the third was like deposit of 80 lakh with the registrar. And the 4th direction.
Your advocate is there, sir. He is taking care of it.
Suffering, sir.
So if you're not
the one who is suffering.
So if you're not satisfied, you take the leave from the court. Your advocate is appearing.
Address.
They are the main contemners. They should be
Correct.
settled.
Correct. Now warrant has been issued. 2 has present. Have been brought under arrest. Police staff. The contempt number 1, 2, 5, and 6 are surrender warrantary before this court. Against the warrant of arrest issues against the contempt number 1, 2, 5, and 6. Police staff. 5. Counsel for the alleged contempt number 1 to 6 submits that I press for time to file affidavit in opposition. Affidavit in opposition. The contempt number 13 has filed affidavit in opposition. Let the same be kept with the record. The counsel for the petition has filed affidavit in reply to the affidavit in opposition in connection with the affidavit in opposition of content number 8, 9, 10, 11, and 13. Let the same be kept with the record. What about the 7 and 12?
Reply is filed today, madam. Yes.
8, 9, 10, 11. 8, 9, 10, 11.
And 13.
13 as well as 7 and 12. Let the same be kept with the record. Police stop. As the alleged content number 3 and 4 have been brought under arrest. Yes, what is your submission? What about the arrest? What is your submission?
My lord, they should be released because We would file our affidavit in 1 week's time, my lord.
But all I'm saying is, my lord, let them, my lord, this is gone, my lord, as your lordship heard, my lord, this has gone on for some time. They are completely recalcitrant. They have never.
I am releasing with the direction to appear before this court on the next
on,
date.
on next Friday, and their affidavit should be there at least 2 days before.
They file the affidavit.
Yes. All of them should be physically present.
Got an arrest, and the alleged content number 1, 2, 5, and 6 have voluntary surrender before this court. Accordingly, they have been released. Released on personal bond of rupees 10,000 with 1 surety each with the direction to appear before this court on each and every date of hearing. And shall file comprehensive affidavit within 1 week.
My lord, kindly make it 10 days, my lord.
Now he'll start.
Not face any further embarrassment, my lord.
Within 10 days, that is on or before 10th of November 2025, by serving the copy to the learned counsel for the petitioner. The petitioner has liberty to file reply, if any, thereto within a week thereafter. List the matter on 18th of November 2025.
So, my lord, I am to file reply to 8, 9, 10, 11, and my lord 1, 2, 4, and 5 and 6 as and when they file.
As the defendants, as the alleged content number 2 and 3 and 4 have been got an arrest, and the other content number 1, 2, 5, and 6 have surrendered. Accordingly, the warrant may be kept in abeyance.
13
मेरे पास है. Then it is allotted to come on 21st.
21st
कर दो.
21st
November.
21st, there is some difficulty. Either a day before.
I don't know.
I know.
That will be the situation.
I know. But probably your lordship will take up contempt matters on Friday.
Yeah, the contempt has to be taken.
So, then the Friday and thereafter.
Then 28. 28.
Grateful, my lord.
Time to have it. Reply them.
Item number 2. Appear for the respondent number 2, my lord.
May I have my lord's leave to appear, my lord, on behalf of the respondent number 1, the contender number 1.
Yes. Hearing.
Yes.
Which for the petitioner?
I couldn't see him or her, my lord.
There is a resolution.
Only the thing is, my lord, if lordship kindly, my lord, takes a trouble to look to the past orders, last 4, 5 orders.
Yes, I have gone to.
But either the petitioner chooses not to appear, or they appear and my lord, take time.
That's why I have
This
gone
is something,
through,
my
but
lord.
today nobody is there, and
Understand,
there
but
is a bar resolution.
yes,
So
but there is
that was
something, my
not
lord,
kept.
is
Not today. Let it come on the or
kindly pass an order, my lord, that recording their non-appearance. And my lord, I say, my lord, my client is, my lord, not even an octogenarian, my lord. He is almost 86, 87 years old. It is nothing but to keep the matter pending and hanging.
for the alleged content number 1, Mr.
My lord, my lord.
1 and 2 are present. 1, 2, and 3 are present. None appears on behalf of the petitioner. Due to the bar resolution, for the interest of justice, the case is adjourned. Let the matter appear on 7th November.
I am grateful. Extremely obliged.
Next.
My lord, I appear for the petitioner, my lord, appearing, my lord, virtually, my lord. These are, my lord, contempt proceedings arising out of.
Mr. Datta, there is a complaint against you that you are missing.
My lord, that day I was actually not in court. I was addressing before another bench, before the division bench. That's the reason I was not there, my lord. Kindly please pardon my lord absence that day, my lord.
Yes.
My lord, this is, my lord, contempt proceedings arising out of your lordship's order of 9th of January. My lord, kindly takes volume 2 once. This is after affidavits. Affidavit in opposition and reply has been exchanged now.
Page?
My lord, page 154 of volume 2. This was in respect of a trust, my lord. One of the properties of the trust was in Ratangarh. Lordship would come back to my lord's that there was an issue with regard to who would control the trust. I had been wrongfully removed by virtue of an antedated document. Lordship had protected me. Kindly takes the operative part of the order, which is at page 158. My lord, the third last paragraph. Considering the above, this court finds plaintiff has made out a prima facie case, balance of convenience and inconvenience in his favor. Court also finds that if at this stage an ad interim order is not passed, there is every chance defendant will siphon off the amount lying in the account. Accordingly, ad interim order in terms of prayers A, C, D, and D, E, and G of the present application is allowed till 5th of February 2025. My lord, kindly takes the prayers, my lord, the prayers which lordship had considered, which is at page 12, volume 1. I have set out the prayers.
I think for 149 is also there.
Yes, 149 it's also there, yes. Because the application is annexed. Lordship had granted A, C, D, E, G. Now, my lord, kindly comes to A. This is injunction restraining defendant from giving effect or relying upon the resignation letter or the supplementary trust deed or the resolutions. C is ordered in the nature of injunction, restraining defendants 3 to 5 from allowing or permitting defendant number 1, who is the contesting wala defendant against whom I am alleging act of contempt, from accessing or operating any of the bank account or assets of the trust, being Kanayalal Ram Kumar Memorial Trust.
Yes, who is appearing for the?
I appear for the main.
Yes.
Then, my lord, D is, my lord, restrained on operation of bank account and other assets.
Yes.
And G is, my lord, restraining defendant number 1 or his agents from taking steps pursuant to or give effect or further effect to the purported agreement of 11th of November 2024. Now, my lord, what had happened, my lord, kindly straight away comes to the act of contempt, which I have summarized in paragraph 23. They had, my lord, despite your lordship's order, appointed a Vyavasthapak at the property in Ratangarh, despite lordship's restraining the defendant number 1 from representing himself as the trustee. Kindly comes to paragraph 23, subparagraph D, which is at page 18 of my contempt petition. Contemptor number 1 has acted in violation and breach of the solemn ad interim order dated so and so by purporting to hold himself out as a trustee and by purporting to assert his purported rights as a trustee of the trust, despite there being a subsisting order of injunction restraining him from interfering in the management affairs of the trust. Contemptor has, in willful deliberate violation of the order, purported to appoint persons as Vyasthapak in respect of the trust property despite being obliged not to interfere in the affairs management of the trust. Knowingly and willfully violated the ad interim order instructing Niranjan Dev Sharma, he is the gentleman who was appointed by defendant number 1, to prevent and or restrain the plaintiff from entering the trust property, which the plaintiff was entitled to do in his capacity as a trustee and in terms of the ad interim order of 9th of January 2025. Now, my lord, when your lordship had passed the order, we immediately communicated this order to, my lord, the defendants. Kindly takes the communication in volume 2 at page 159. Because it was an order of 9th of January, my lord, we had communicated the gist of the order at page 159, which is a letter of 9th of January. My lord, volume 2.
Yes.
This was, my lord, this was communicated to, my lord, kindly sees the first addressee, Devakinandan Chaudhary, who is the alleged contemptor here.
Yes.
My lord, this I have disclosed the, my lord, service report as well as the postal receipts, which are at 161 and 162 onwards are the, my lord, track reports. No dispute with regard to, my lord, in the affidavit that they did not receive this communication. Now, because the order was also, my lord, passed on 9th of January, immediately when we got it from the server, my lord, we communicated a copy of the order also the next day, which is at page 173.
Yes.
And at 174, my lord, for convenience, we had also, my lord, set out the reliefs which we had claimed. Inadvertently, it went down as the reliefs in the suit. We corrected that and we made it the reliefs of the application. Later, my lord, there is a correction to this effect. But last line is important. Copy of the order of 9 January is enclosed for your ready reference. Enclosure as above. This was also served. Postal receipts at 175, track reports at 176 onwards. They have been delivered.
Yeah.
My lord, when they appoint, my lord, the first this Vyasthapak at the Ratangarh property, my lord, when we come to know, we issue a contempt notice through our advocate. This is at page 221.
Where is the order of appointment, Vyasthapak?
My lord, there is no order of appointment. Lordship had permitted, because of the order, interim order, I was permitted to go and visit the property. When I visited the property, this is the person who on behalf of respondent number 1 obstructed my entry. As a result, I come to know that despite this order of your lordship, I was not being allowed to enter the property. Kindly takes the notice of contempt, my lord, at page 221. At page 222 is the relevant part. Subparagraph, my lord, H. On 13 January, our client went to Ratangarh and upon reaching there went to the property of the trust. Upon reaching the trust property, our client was restrained by Niranjan Dev Sharma, who claimed to be one of the 3 persons purportedly appointed by you as Vyavasthapak of the property of the trust, along with Srimati Kailas Devi and Sri Hari Bhagwan Sharma. Sri Niranjan Dev Sharma also refused to permit our client, who is a trustee of the trust, from entering the trust property and proclaimed that he did so on your instructions. By your, I mean, my lord, the defendant number 1, Deokinandan Chaudhary. Such appointments made by you is patently in violation of the order of 9 January, as by the said order you have also been restrained from acting as a trustee of the trust. Inasmuch as you have been restrained from acting as a trustee of the trust, you could not have appointed Niranjan Dev Sharma as the Vyavasthapak of the trust property at Ratangarh. Our client states that such action on your part is illegal. Contrary, this is, my lord, for the purpose of contempt, subpara J and K. I'm not reading it, my lord, just to, my lord, save some time. Yes. They have replied to this, my lord, contempt notice, and the usual, my lord, defense has been taken that this is an appointment which I gave to Niranjan Dev Sharma prior to your lordship passing the order.
Yes.
Kindly comes to page 225. The relevant allegation, my lord, has been dealt with at 226. My lord, will kindly take 226 foot of that page. There is a clause 1 or para 1, appointment of Niranjan Dev Sharma as Vyavasthapak.
Yes.
I had visited Chaudhary Bhavan Ratangarh on 18 December. This is, my lord, Deokinandan's version, and stayed there for about 3 weeks till 7th of January 25, during which Niranjan Dev Sharma was kept on trial basis to assist me in looking after the work and activities of the trust, and was formally appointed with effect from 1st January or at a salary of 5,000. Now, my lord, the moment they say 1st of January, they are crossing, my lord, they are before 9th of January order of your lordship. Now, if they say that they have paid salary 5,000 rupees, they had to disclose, my lord, documents to establish that 5,000, how it was paid, because after all, he is an agent of the trust, being an employee of the trust. Now, kindly sees, my lord, their defense to this effect. His appointment at what time was in addition to the following 3 support staff, so and so. Payment of the monthly remuneration of that was being paid from the trust bank account, but your client wrongfully sent various letters to bank causing them to freeze our accounts. Now we are unable to pay from the trust account, putting the trust into crisis. As such, to resolve the crisis for the time being, I was compelled to pay all expenses relating to the trust from December 2025 from my own account. So lordship had restrained him to represent himself as a trustee of this trust, because prima facie lordship found that he had interpolated a date to, my lord, give a representation that my client had resigned from the trust as a trustee. That was challenged by me in the suit, and Lordship had injuncted him. And the nature of the injunction was that he would also not represent himself as a trustee till such time Lordships finally decide. Now the interlocutory application is being decided by a coordinate bench. But this is, my lord, an act of contempt on the face of it. In teeth of the order of 9th of January, this could not have been done. Then, my lord, he describes, my lord, the incident of 13th January when I said I was obstructed. This is his version, para 2. Oh, my lord, may I just, 227, subpara B also may I just read? Since his appointment predates the court's order, his position and authority remain unaffected by the injunction. This is very safe defense, my lord, to avoid contempt. But he is not in a position to show that the trust was paying any amount. That is why the defense that I paid from my personal account. The injunction does not restrain Niranjan Dev Sharma from carrying out his responsibilities as Vyavasthapak of Chaudhary Bhavan. My lord, at least, even if I take it on the face of it to be correct, my lord, in view of Lordship's order of 9 January, this gentleman cannot continue thereafter. My lord, but this gentleman still continues to be, my lord, a Vyavasthapak at the trust property. Alleged incident at Chaudhary Bhavan on 13 January. On 13 January at around 10 p.m., Mr. Sanjay Chaudhary, that is my client, plaintiff, Mr. So-and-so and Ronak Chaudhary and Vishal Sharma, along with unknown individuals, attempted to forcibly enter Chaudhary Bhavan. My lord, there is no question of me attempting to forcibly enter when I had got the protection from your lordships, the 9 January order. There was a stay on the resignation which had the effect of, my lord, me coming into the same position as that of a trustee as I was prior to the order, prior to the resignation letter. Mr. Niranjan Dev Sharma, who was inside the premises, came out after hearing loud noises and witnessed the unlawful entry attempted by several unknown individuals. Kindly marks this, my lord. So after 9th of January, on 13th of January, Niranjan Dev Sharma is coming out of Chaudhary Bhavan. On seeing Niranjan Dev Sharma, unknown individuals began to raise the tone of their shouting and used abusive language, started recording videos of Niranjan Dev Sharma in an intimidating manner. I call upon you to produce the same. In response, Mr. Sharma took photographs of trespassers for record keeping and security purposes, which I will produce before the honorable court. So, my lord, this is precisely, my lord, their stand in the, my lord, reply to the contempt notice, as well as, my lord, in the opposition which they have filed to my contempt petition. My lord, the point is very, my lord, short. After your lordship's order of 9 January, my lord, if I know lordships have a very limited jurisdiction in contempt, and lordship may not go into a contentious issue. I am saying that his appointment is prior to, his appointment is after the order of 9th of January. His response is, no, I had appointed him prior to 9th of January with effect from 1st of January, but I was paying him not from trust account, but from the account of my personal account. Lordship would test this defense just to avoid, my lord, the acts of contempt. This is, my lord, a story which has been spun for the first time, my lord, in this response to the contempt notice. This is not permissible. Now, my lord, I will also take your lordship to a very other serious, my lord, offense committed by this, my lord, gentleman, same gentleman, and I will draw inspiration from that act to suggest that even this is, my lord, not acceptable. Lordship is hearing 2 contempt petitions today. One is item 3, that is another application, item 4. My lord, let me also show the act of contempt there so that my learned friend can respond to both the, my lord, acts of contempt. Kindly takes, my lord, the next application, which is item 4, takes my contempt petition.
Yes. Yes.
My lord, here again, order, I am not troubling your lordship. Order I have shown from the first, my lord, page, first contempt petition.
Yes.
Kindly comes to, my lord, the supplementary affidavit which is there in connection with, my lord, this contempt petition. One document I will show, and on my lord, on the face of it, my lord, this would reflect the act of contempt committed by this gentleman. Lordship has the supplementary affidavit.
Yes.
Kindly comes to, my lord, page 7 of the supplementary affidavit. This is, my lord, an income tax, my lord, return for the assessment year 2023-2024.
Yes.
At the top right hand corner, lordship will get the date.
Yes.
It is 29th January 2025.
Yes.
Now, my lord, just after that, there is a part A general written in bold.
Yes.
Name of the SSE thereafter is mentioned, my lord, that's the trust's name, Kanhaiyalal Ramkumar Memorial Trust.
Yes.
Now, my lord, kindly comes to page 62.
Yes.
Lordship has 62. 29 January, again, the date of filing is there at the top right-hand corner.
Yes.
Kindly sees the name verification. Devki Nandan Chaudhary, son, daughter of Bholaram Chaudhary, solemnly declared to the best. So it is, my lord, at the instance of Devki Nandan Chaudhary that the income tax return of the trust is being filed on 29th of January 2025, despite your lordship's order of 9 January 2025 restraining him from representing as a trustee of this trust.
Yes.
Now kindly takes the affidavit in opposition they have filed, my lord, in this contempt petition. And comes to paragraphs 29 to 36 of this affidavit in opposition, which starts at page 20 of the opposition, my lord.
Page 20.
Page 20 of the opposition, his version starts from para 29 regarding this. My lord, 29, he says again he was there in Ratangarh from December. 30, after the return of the defendant number 1 to Calcutta, the defendant number 1 visited the office of the chartered accountant on January 8, provided the relevant instructions, clarifications as regards the alleged demand. Auditor was instructed to comply with the income tax demand so as to ensure demand is not finalized upon public charitable trust. It is pertinent to mention that certain statutory compliances are required to be done on a monthly basis and frequent intervals for which no special instructions are given. It is the auditor who had filed the revised return on January 29, 2025. My lord, that is why I showed page, my lord, 62 of the, my lord, contempt petition. It is not the auditor. Auditor is only uploading the document at the instance of Devki Nandan, my lord, Chaudhary. It is the auditor who had filed the revised return on January 29 on the basis of clarifications given by defendant number 1. It is pertinent to mention that on and after January 9, no further instructions were given to the auditor for income tax demand for assessment year so and so. It is stated that trust is a public charitable trust, and had the auditor not filed revised return in view of the public interest, trust would have incurred a tax liability of 31,56,930. Revised return filed by the auditor was accepted by income tax department and demand was set aside. Income tax had issued a refund of so and so. So on one hand, my lord, he relies upon he is saying that this is an income tax return of the trust, but he tries to justify and come out of the acts of contempt by saying, no, it is the auditor who had invited me to give these instructions because there was a demand from income tax authorities, and my last instruction given to him was on 8th of January. Again, my lord, the date is significant because 9th of January, lordship had passed this order restraining him from representing as a trustee. Now, my lord, I would have understood, to be fair to my other side, my lord, he would have come to the court with an application saying that please give us leave to instruct the auditor post 9th of January order because there is a demand from the income tax authority. It is in the best interest of the charitable organization. So please permit us to follow up this with the income tax, with the chartered accountant so that appropriate return can be uploaded or filed. He does not do that. When I allege contempt by relying upon this document, this is, my lord, his defense.
Yes.
Therefore, my lord, I am saying from both the petitions, my lord, the acts of contempt as well as the defense which my learned friend on the other side is raising, my lord, on behalf of his client, as if, my lord, whatever act he has done is prior to the order of 9th of January and he has not done anything after the order of 9th of January. Now, apropos these two things, my lord, I say, Niranjan Dev Sharma continues to be, my lord, the Vyavasthapak at the property, which, my lord, that appointment, my lord, could not have been done. This appointment, and if it is continued, it is in the teeth of your lordship's order. Second, my lord, the document, the income tax return on the face of it shows a date of 29th of January. which is after the order of 9 January, this is again on the face of it, my lord, an act of contempt. Therefore, my lord, I would invite your lordship to be very strict with this, my lord, litigant and pass appropriate orders against him. My lord, only one submission possibly my junior would like to make. My lord, he wanted me to rely on one document. I would request Mr. Mukhopadhyay to rely on that document. Kindly permits Mr. Mukhopadhyay, my lord, who is there, my lord, to rely on that document, my lord.
To supplement one my lord, in the prior contempt application, that's item 3, my lord, that letter that Mrs. Dotto had placed of the defendant number 1, my lord, paragraph 2E also, my lord.
Which one?
My lord, the item number 3, the second volume, page 227. 227, which Mr. Dotto was placing, my lord, just now. Page 227, if my lord only sees Mr. Dotto had placed till D, my lord, E also, my lord, will kindly see. One of our alleged, my lord, acts of contempt on behalf of the petitioner against the defendant number 1 is that we were restrained from entering into Chaudhary Bhavan, the estate in Ratangarh. My lord, 2E, my lord, will kindly see the claim that Mr. Sanjay Chaudhary was restrained from entering the property by Mr. Niranjan Dev Sharma is entirely false. Rather, Mr. Niranjan Sharma stopped the unknown individuals. If my lord reads the entirety, the unknown individuals is Mr. Sanjay Chaudhary and his family. That's the only people referred to. He admits that they were stopped from entering into the property. They allege that they were trying to trespass, but in fact, this is really a subterfuge. It's actually Mr. Sanjay Chaudhary, that's the plaintiff petitioner, and his family members who had gone to enter the property. Admittedly, they were stopped and restrained by Mr. Niranjan Dev Sharma on the instructions of the Chaudhary. No, that's the only thing, I wanted.
My lord, those are our respectful submissions, my lord, in the contempt petition.
Well, I am going to reply on item number 3 today, my lord. 4, I thought that will be taken up on the next day. I'll reply on 3, CC 27. So far as, my lord, at the outset, I'd like to submit, my lord, that the alleged contemners, my lord, have deepest of respects to the orders passed by this court. But, my lord, has there been any act of contempt committed by the alleged contemptor? Your lordship may kindly seize.
Where is the order of appointment and the resolution
Yes,
of the trust?
yes, my lord, I shall show, my lord. Just kindly
Show
give
me
me
the
a moment.
trust, first to show the trust.
Yes,
resolution.
that's at, my lord, page 20 of the opposition. I'm sorry, page 21. But your lordship may kindly allows me to take my lord through the order. I need to show one thing.
Yes.
Yes. Lord, before my lord takes this order, this communication, your lordship may kindly comes to my lord's order dated 9 January, which is allegedly the act in contempt.
Yes.
Or the order in lord in contempt. Lord, first of all, I'd like to submit, your lordship, the operating portion at page 158. Lord says that the court finds the plaintiff has made out a prima facie case. This court also finds that if at this stage an ad interim order is not passed, there is every chance that the defendant number 1 will siphon off the amount lying in the account of trust. Accordingly, an ad interim injunction in terms of prayer A, C, D, E, and G of the present application is allowed till 5th of February. The plaintiff is directed to serve the copies and such immediately and to file affidavit service. Now, my lord, this order, my lord, in whatever understanding, my lord, did not permit the plaintiffs to barge into the property. Now, so far as restraint is concerned, this prayers, my lord, A, C, D, and G, my lord, just kindly have a look at the prayers once. That prayers is at page 149. They are really aggrieved, my lord, from the fact that they were not allowed to enter. My lord, order, first of all, prayer A, my lord, is restraining me from not to giving effect to the letters of resignation. This is not the concern right now. Prayer C is, my lord, restraining the other defendants, my lord, from allowing me to access the bank account. This is also not the concern. Prayer D, in the nature of restraining defendant number 1 from accessing and or operating any of the bank accounts and assets of the trust lying with the defendant number 3 to 5. That's the bank accounts. 3 to 5 are the bank accounts. And, my lord, E, restraining from interfering in the management of trust or in any manner dealing with the assets, properties of the trust, being said such in paragraph 9 herein above. E and, my lord, G. And, my lord, restraining defendant number 1 from giving any step to the agreement dated 11 November 2024, not concerned. Now, your lordship may kindly comes first of all the chapter of appointment of Mr. Niranjan Dev Sharma.
Yes.
Lord, Mr. Niranjan Dev Sharma was appointed on 1st of January 2024. And, my lord, we have given a document that after his appointment, his name was, my lord, colored outside the gate of the Kanhaiya Lal Trust in Rajasthan. That's at page 20, that bill. Painter Dinesh, that's bill kindly sees 4th of January. And Lord, everything is there. The bill of 400 rupees for painting the name of Niranjan Dev Sharma. Now kindly comes to the next document. That's 8th of January 2025. 8th of January, my lord, obviously is prior to 9th of January 2025.
What is this? Page 21?
Page 21, my lord, is the resolution by the trust appointing. Translated version, your lordship may kindly sees at page 21A. I wanted to show the part.
What is the 20? What is the painter?
20 is the my lord, the name which after appointment, Niranjan Dev Sharma was appointed on 1st of January. His name was painted at the gate. Now, my lord, next page, page 21 is the resolution. Resolution is dated 8th of January. And at the bottom, your lordship may kindly sees this was notarized on 10th of January.
Correct.
Yes. So now, my lord,
this is the certificate. Where is your minutes?
This is the minutes.
Can't be. To whom it may be concerned can be a minutes.
My lord, by this way he was appointed.
And you are paying the income tax. Can the trust be maintained? The whatsoever it may concern.
Lord, this is the minutes by whom he was appointed. This is not in dispute, my lord, right now. He is saying that we have appointed.
There is no dispute. With regard to appointment by any of the persons in the trust, there should be a resolution in our minutes of the meeting. This is a certificate.
No,
you can take the certificate from anywhere. And how the notary can identify the certificate? Where is I am asking, the court is asking, or I am directing to produce your minutes book of minutes.
My lord, we can produce, my lord. There is no my lord, hide and seek. And so far as your lordship may kindly sees the sequence of us being
by which resolution you are appointed?
My lord, this is that resolution.
It
my lord,
can't be, sir.
Your lordship may kindly sees my affidavit. I have explained in my affidavit.
That's why my first question, I have gone through your total affidavit when Mr. Datta was arguing. That's where is the evidence, where is the content, where is the statement that the meeting was held, trust has to hold a meeting and the resolution was passed, thereafter he was appointed. This is a certificate to whom it may be concerned can be a resolution.
By this resolution, if I may call this as a resolution, by this resolution he was appointed.
I am not,
he
the
was
court is
appointed
not accepting this.
He was appointed on 8th of January and Lord, this was
okay, let's present before this court.
Notarized on 10th.
He will be present before this court.
Lord, I have other points also.
No, first of all, you are appointed.
Yes, my lord, I will.
Your client has played the fraud before this court.
No, your lordship, this is not
by using the forged document.
This was there, my lord, prior. Your lordship may kindly sees at page 20 that receipt, page 21 the appointment.
20, with regard to 20, what? That's why I'm asking. 20. What is the 20?
20 is the receipt, my lord. After
what
appointment.
What is the 20 receipt?
After appointment.
When appointment was made?
1st of January 2025.
1st of January. Kindly see this 21.
Yes, 21 is my lord.
When it was issued?
8th of January.
That's the 1st January. Where is the appointment? Where is the resolution?
Lord, there is no such resolution. Lord, titling the document as resolution.
You are making the board on 4th. You are making the board on 4th.
The bill is
on the painter.
Bill is on 4th.
Correct. 4th.
Yes.
And you are giving the certificate on 8th. And your contention is that he has been appointed on 1st. Where is the appointment?
Lord, appointment is by way of this resolution, Lord.
On
this was the practice earlier also. My learned friends, since now have filed this contempt, they are saying that no, you have made it
not
before.
No.
Now, Lord, coming to the point of 13th January incident, when they say that we didn't allow them to enter. Your Lordship may kindly sees page 31 first. AO. 31 of my opposition.
31 of?
My opposition. I believe, Lord, my Lord has been provided a colored copy. Your Lordship may kindly sees page 31 and 32. In the pleadings, my learned friend's client pleads that it was the plaintiff Sanjay Chaudhary who had visited the premises. Whereas, my lord, when we took the photo, this was at 10:30 at night. Lord, coming with 6-7 people, and your lordship may kindly sees we have tried to identify. One is Ronak Chaudhary, son of Sanjay Chaudhary's son. Lord, they all come at 10:30, Lord, at night, and they barge into the premises.
Is it possible to see the photograph? This is the photo you have annexed.
Yes, Lord, we also have a police report after that.
This is a photo. Where is the original photo?
Lordship kindly gives me a moment.
Where is the original photo?
Are colored photo diye chhe. Your Lordship may kindly, if I may be allowed to provide this one. Even this is not colored, but the resolution is much better. Kindly see, my lord, we have identified the people. At 10:30 they come.
It is again same. Where is the face of the Ronak Chaudhary?
From the iPad, I get to.
No, it is there.
Wearing specs, my lord, your lordship, kindly see.
The same photo.
এই দেখুন এই যে এইটা যেটা আছে এটা দেখুন এটা দিয়ে আমরা এটা দিয়ে এই অ্যারোটা এই ফেসটা দেখতে পাচ্ছেন এই ফেসটা এই অ্যারোটা দিয়েছে ওই ক্লায়েন্টের ছেলে Lord, that is the son of the plaintiff, my lord. They, my lord, create ruckus at my lord 10:30, 11 at night, and my lord, this place is famous, my lord, for dacoity. I have my lord annexed newspaper cuttings also, which in the very recent times have reported dacoity.
So the court is not interested to
Your
go
lordship,
with
they
the
are
dacoity and
primarily, my lord, they are
only the court first of all you leave aside. I am not taking cognizance, not allowing them because there is no prayer on that. First you satisfied this. Where is the resolution by appointing after the order of 9? Where is that?
Very well, Lord. Kindly.
You satisfied this court that he was appointed by way of a resolution which was the first of before the 9th of January.
Lord, kindly gives me a moment. Lord, this is that document we have annexed. I will, my lord, try and arrange the minutes book, my lord, and try to produce on the next day, my lord, so far as this is concerned, because this is the only document and this was it is not that this was the only practice maintained. Earlier peoples were appointed and removed. This is how they were appointed and removed.
So
now, since he's ousted.
So how you filing the income tax without maintaining the proper document?
Yes, my income tax, my lord, there is no dispute so far as maintaining of the documents are concerned. But my lord, this is the manner.
Then you come to the supplementary. Come to the supplementary.
That one.
Kindly come to the supplementary.
Yes, my lord.
Of the second matter, 65.
Yes, my lord.
Page 62. I further declare I am making this written in my capacity and others. How you can do this on 29th of January when the court has restrained you?
Lord, this has been filed by the auditor. I have also
kindly come 62. You have signed.
This is, my lord, 62 is the downloaded form from the income tax department. It is not a typed form like we do in the affidavit. This comes, my lord, pre-printed.
Sir.
Name and everything.
Sir, kindly see the date.
Yes, my lord, 29 January.
Then
29 January, my lord, I have categorically stated that I have not filed.
Where is the statement that is
yes. Kindly comes to, my lord, my affidavit.
Then I will issue the notice to your auditor also. I will issue the notice to your auditor also.
Your lordship may kindly
hold the hand and glow.
Lord, this is my lord.
Sir, I know.
This is the filing.
I was there for 25 years.
Yes, my lord.
And I have dealt with all this type of the matters.
In that case, my lord, kindly allows me a minute. There was initially, my lord, a demand of 31 lakhs on the trust.
I am asking one question. How this 29 January you have signed, this has been uploaded once you are not, the court has been restrained.
Your lordship may kindly come.
If you tell that your auditor has been done this without your knowledge, I will call the auditor.
Lord, upon my instructions, which was given prior to the order, my lord, I am saying, my lord, this filing of return, my lord, of the income tax department, my lord, where
Sir, verification date is 29
yes,
January.
Yes. What I am saying, my lord, is that filing of return by the income tax department, by the auditor, my lord, neutralizing the demand, which has the effect of neutralizing the demand on the trust, my lord, is not an, my lord, kindly seize my statement, first of all.
Yes, where is the statement?
My lord, my statement is at paragraph 32 of my affidavit. And so far as your lordship's query on minutes,
which
page 20, opposition to page 65.
Yes.
Yes. My statement is at paragraph 32. My statement is at paragraph 32 of the AO, my lord. I have already stated that, my lord, the clarifications were given immediately after my return. That was on 8th of January.
Where from your return?
My lord, from Ratangarh.
Where is the document you written from the
My lord, that I can disclose, my lord. My lord, that I can provide. I have that document that I can provide.
Let you and auditor be appear before this court.
Your lordship, may kindly do not call for personal
Yes,
appearance.
yes.
Kindly gives me an opportunity to explain on the.
I have not satisfied. Let he come.
My lord, your lordship may kindly seize.
Your auditor also, both. Let the auditor, what
Kindly
is the
gives
license number, I will also see.
Lord, may kindly do not call for personal appearance. This is my request, Lord. On the next day, I shall try and satisfy all my Lord's queries, so far as these questions are concerned.
Then you manipulate.
No,
you
Lord,
will
there is no
manipulate.
question of manipulation.
Once you already filed
I'll-
the manipulated document
Lord,
before the court.
it will be all on the basis of the documents disclosed. I will, my Lord, answer, my Lord, so far as your
You
Lord
just you stated that there is no resolution.
Yes,
This
my
is the
lord,
only certificate
this
which
is
have
the
been
only
appointed.
practice.
How
Your
you can?
Your lordship is
That's why
asking-
how you cannot improve unless and
No,
until
I
you
will not improve. I will, my lord, try and satisfy, my lord, with whatever information I receive, so far as this is concerned, because this was the earlier practice.
Let he come. Let he come.
Your lordship may kindly do not. On the next day, I shall try and satisfy my lord. If on the next day your lordship is not satisfied, then my lord may kindly do
My
not.
lord, this was a litigant who had manipulated the resignation letter also. That is why lordship gave the interim order.
Mr. Alim,
Yes, my lord.
you are the beginner.
Yes, my lord.
I am again cautioning you to file this type of the affidavit.
My lord, this
as per before this court.
Yes, my lord.
You made to the I don't know, but before this court, sorry, and then you will be in trouble. I will not bear who will appearing. Who is appearing before me? Since beginning, when I have taken the determination, I told I have two things I have reserved with regard to misleading, and second is adjournment. Clients may come and go, but you being the court officer, we come before this court with a clean hand.
Lord, whatever I am submitting is based on the.
You are doing so many trust matter. Whether the trust is going with the to whom it may be concerned, that will be appointment order without the resolution of the trust.
Certainly not, but this was the practice which was prevailing earlier.
Maybe
now, since my learned friend is out,
now you are coming before the court. You have any idea whether the court will accept that will be the appointment order without the resolution? That is to be that is trust, and there is an allegation against you that you are manipulating or you siphoning of the fund. There is an allegation in the case.
Lord, that is Lord.
And for that, and you coming with that to whom it may be concerned, and you have appointed.
Lord, I cannot better the records. This was the practice which was there earlier, which has been disclosed. That is why I'm saying, Lord, kindly gives me Lord.
Giving the note, and to whom it may concern, it has been notarized by the advocate.
No, not advocate, Lord, notary.
Notary, who is the notary? Advocate only. The third person cannot be a notary without an advocate.
Yes.
Then, what is the necessity of the notary on the certificate? After hearing the learned counsel for the parties, this court find that the alleged contemner has relied upon the appointment of Vyastapak, namely, what is the name?
Niranjan Dev Sharma. Niranjan Dev Sharma.
Niranjan, Niranj, Niranjan Dev Sharma. Learned counsel appearing for the contemner has relied upon the certificate dated 8th of January 2025 and submits that this is the only document, and this is the document on which Mr. Niranjan Dev Sharma was appointed as Vyastapak of the trust. This court failed to appreciate how, by way of a certificate, one person can be appointed without the resolution or minutes of the meeting of the trust. Accordingly, the alleged contemner, namely
Devki Nandan
Chaudhary, is directed to appear before this court in person along with the minutes book of the trust on the next date fixed. Let the matter appear on 14th of November 2025 at 2 p.m.
Grateful, my lord.
Lordship, I appear for the applicant. So
May
appearing.
it please the Lordship, my lord, I am leading Mr. Mukherjee, my lord, I appear for the applicant, my lord. This is my contempt application in
Yes.
connection with the defamation suit. My lord,
Yes.
your Lordship, at the occasion of taking up this matter and passing the interim order, my lord, the defendants in the suit are the three newspaper companies. My lord, three newspaper or my lord, print medias and electronic medias, my lord, who have published defamatory articles concerning my client in their website. If your Lordship kindly sees the order, which is at page 41, the order under contempt.
Yes.
But kindly sees the order.
Plaintiffs are directors. Yes. Who is for the contempt now?
Now, the relevant portion, my lord, will find last line at page 43, going into page 44. My lord, your Lordship's pleasure was restraining the defendants from publishing any post and, my lord, removing the defamatory articles from the post. Despite that, my lord, and despite having served them, my lord, they have continued with the posts even after the impugned order. I'm sorry, even after the order.
Yes.
My lord, they cannot feign ignorance of the knowledge of the order because they have themselves filed an application for vacating of the order.
Yes.
So, my lord, the knowledge they cannot, my lord, feign ignorance of.
Well, the knowledge of the order came to us. This was an ad interim order which was passed by my lord. Well, thereafter, the matter went up to the bench of justice, my lord Justice Mukherjee. My lord, there, my lord, we entered appearance.
Where? Which court?
My lord, Justice Arindam Mukherjee, my lord. My lord, there, my lord, we have not only given an affidavit in opposition to that, we have also filed vacating. Well, there are two aspects of this matter. One, my lord, there is this operative part has two parts. One, that we should not act in furtherance of this order. Second, we have to take it down. So, my lord, my lord, this order was admittedly passed ad interim. We had no knowledge of it when the matter was taken up. So, my lord, with the vacating application being filed and it's being pending, my lord, I have filed the vacating application in due time. My lord, with the pendency of the vacating application, if the contempt, my lord, if we take it down, my lord, my vacating application goes infructuous. Well, the vacating application it's pending. Well, the affidavits have been exchanged. There were time, well, they had also sought some time for filing of the affidavit. Concessions were granted. Vacating application could have been filed. And my lord, Justice Mukherjee was pleased to have the matter, both the matter heard analogous. Well, this will come in the monthly list of November. We can hand out the order. So, my lord, my prayer is, if my lord pleases to adjourn this matter until the decision of that matter. Well, once it's decided, well, then I go out. I'll have to comply with it anyway.
No, even though now, as on date, there is an ad interim order.
I understand.
Have you complied with?
Well, as far as this compliance part is concerned, my lord, I've not acted in furtherance of it. One part. As far as the second part is concerned, my lord, if I would have had taken it off, my lord, if I take it off, my lord, then my application goes, well, my application for vacating becomes infructuous. Well, this is, well, the second part of the order was, well, to take off the article which is alleged to be defamatory by the plaintiff.
Correct.
Well, my case is that, my lord, this is not defamatory. Bonnard principle, my lord, there are elements of truth, and otherwise I am running a case of suppression of material facts before the court. Well, these are the case. My lord, in this case, my lord, if I take it off, I understand, my lord, an order which is subsisting is a good order until and unless it's reversed. There's no stay also. I'm not saying that there's any stay. But my lord, my vacating application being pending, my lord, if I take it off, my vacating becomes infructuous in that case. So, my lord, my only request is, my lord, urge, my lord, until my lord, it will be taken up anytime in the, my lord, from the monthly list of November. Until then, my lord, will kindly adjourn that. My lord, there are applications, my lord, and there are orders. Huh?
You are not publishing or posting anything further?
No, my lord, I have not.
Can I record this?
Yes, my lord. My lord can record that. My lord can. And my lord, kindly until my lord, the both the application, their application and my application for vacating is decided.
Yes.
My lord, two things to the submission of my learned friend, my lord. Firstly, we did not move this application ex parte. We served them. My lord, they received the service in the addresses mentioned in their websites.
No, my lord.
Second.
My lord, if in that case, my lord, I'll give affidavit, my lord. If this is the submission, my lord, I'll have to give affidavit.
Yes, this has all along been the submission. It's nothing new. In fact, in our affidavit also we have stated that. My lord, yes.
My lord, in that case, my lord, it's insufficient address, my lord. I'm assisted by my learned friend.
Yes, it's coming as insufficient address. Yes. If their website shows this address, we have tried to serve, it's coming as insufficient address.
My lord,
From their website, I've shown that. My lord, we had not moved this ex parte. We had moved this.
I had sought for to serve it on me. I voluntarily served. My lord, I have not taken any advantage of that.
My lord, now 2-3 other things. It's not that they had immediately come up after the order for filing a vacating.
The list of
matter had come up before the court on a few occasions.
Gupta now is appearing. Let him file the affidavit.
My lord, in that case, my lord, I'll file the affidavit. My lord, as far as my lord, if just in case, my lord, my lord, can we just wait for the fate of the litigation, my lord, fate of the two applications, my lord, which is pending before Justice Mukherjee. My lord, without that,
when is the matter fixed? Next
monthly list of November. Last order to now.
I don't think so now.
Monthly list of November. Monthly list of November. My order to now.
Yes. It's come. It's due to appear in the monthly list.
Okay, I am fixing up the second week and third week of November.
Very well,
with the leave of my learned senior lordship, just one thing maybe I have, lordship, there were two contemners. On lordship's previous order, we've served. Learned senior friend is appearing for contempt number 1. Contemptor number 2 has still chosen not to appear.
That, my lord.
If the affidavit of service is here, lordship, it's come back. We've served them by post, also by mail, which was we had earlier also filed, and lordship, in your lordship's own order had recorded that we had filed it. Lordship, we filed it. We've served it on mail. Lordship, the affidavit of service is in hand. This is in regards to the alleged contempt number 1. Contempt number 2 has not yet entered appearance, even in the. My learned senior can.
Yes. So what is our submission?
Yes, so I think Mr. Yes, only one contemptor is being represented who had filed a vacating. So far as the other alleged contemptor, which is a different publishing, they have not entered appearance. They have not. So he's not appearing for everybody.
No, I'm not appearing.
The counsel for the alleged contempt number 1 submit that the alleged contempt number 1 has already filed an application for vacating the interim order passed by this court, against which the present on the basis of which the present contempt application is filed. The alleged contempt number 1 prays for time to file affidavit in opposition. That affidavit in opposition is filed within 2 weeks. A reply, if any, there to be filed within a week thereafter. Full stop. It is submitted by the learned counsel for the petitioner that as regard the service upon the alleged contempt number 2, not served.
Lordship, it's come back as insufficient address, served by email, my lords. That service is complete. I've handed over the affidavit of
with
service.
regard to the postal service, it has been written unserved with the endorsement insufficient address. But the learned counsel for the petitioner submit that the same was also served through the email, which was duly received by the alleged contempt number 2. But
my lord, in that case, my lord, one way from this court, my lord, we will also pursue to have the matter heard. My lord, let there also be no, my lord, adjournments on the part of the plaintiff. My lord, since they are enjoying an ad interim order.
Where?
My lord.
Contempt application.
Not contempt application.
That
my
I will not.
My lord, I understand, my lord. My lord, at least, my lord, what will happen, my lord? Because my lord has kept this matter. My lord will, of course, will not be able to remember. My lord, if there is adjournments and concessions that are being sought for in that court, my lord, my relief lags over there. And my lord, here I'm here to face my lord. My lord, that becomes a double jeopardy. In
okay, if it's not, then you review your submission before this court on the next date.
I'm so grateful.
The affidavit of service filed by the contempt petitioner is kept in the record. Full stop. As the alleged contempt number 2, in spite of receipt of the notice through mail, is not appearing. Thus, this court has no other option but to issue the warrant against the alleged contempt number 2. The petition is directed to take appropriate step for issuance of the warrant upon the alleged content number 2, and the registry is directed to take appropriate steps for execution of the warrant upon the alleged content number 2. Full stop. Let the matter appear. Let the matter appear on 27th November 2020.
I'm so grateful.
I'm grateful.
28 korte.
28. I'm grateful.
My application, my lord, appearing for the first time, my lord, kindly comes to my lord order of my lord 27th of March at page 20. My lord, this is a suit for my lord defamation. My lord had restrained my lord the respondent number 1 from publishing my lord any my lord kind of my lord post my lord in the portal of my lord respondent number 2. Now my lord kindly comes to my lord page 20.
Yes.
Now my lord takes my lord page 27, paragraph 17. The respondent number 1, despite selling his share in the company and the name of the respondent number 1 not being reflected in the records of the company, despite which the respondent number 1 misrepresented himself as a shareholder of the company. The respondent number 1 had made defamatory post in the platform of the respondent number 2 and further circulated wherein it is stated that the petitioner is a habitual cheater, has stolen shares from one Milan Ghosh, associates with habitual fraudsters, and the achievement of success in the business world is tainted with illegality. The complaint made by respondent 1 against the petitioner is totally false. This court finds that the petitioner has made out a prima facie case in favor and balance of convenience inconvenience in favor of the petitioner. This court finds that if the stage ad interim order as prayed for by the petitioner is not granted, the petitioner will suffer irreparable loss. Considering the above, respondents therein, main agents, servants, and assigns and representatives are restrained from posting any article or post against the petitioner orally or in writing any defamatory words till 30th April. Now, Millard kindly takes Millard. Millard, I'll show the extension orders. Millard kindly takes Millard the communication at page Millard 33.
Yes.
Millard, this is a communication, and Millard, my lord, order Millard is part of Millard notice of motion and plaint and order Millard last attachment. My lord will see at page 34. My lord's order 77th March. Now Millard kindly see Millard. He appeared on 30th of April or at page 29 after receiving Millard notice.
Yes.
And Millard interim orders are time to time extended. Kindly see Millard page 29. Respondent number 1 is represented. Appearance is there. Now Millard kindly takes page 30. Represented, second row of appearance. Now Millard kindly comes to Millard page 35. Millard on 5th of page 35, 5th of September. Kindly see allegation again Cosmic CRF. Again Millard, despite the thing Millard he has been appeared. Fraudster allegations are all these are Millard. Again same Millard, copy paste Millard. Post Millard in the web Millard portal of respondent number 2. Millard, this is at Millard 5th of August, then Millard 5th of September, then Millard 8th of September at page 37, and thereafter 9th of September at page 40. Millard series of similar kind of. Now Millard, I had given him a notice that I will issue a contempt against you. That is at page 43. 42. 22nd of September. So he is aware of the facts. 42.
Yes.
Millard, in view of that, I will kindly issue a rule and serve on the response contempt.
Issue notice.
Kindly issue the rule, Millard, because it's blatant. Millard, then Millard, we follow that Millard rule is issued if Millard is satisfied. If Millard is dissatisfied, then only Millard affidavit we ask for.
The petitioner has filed the present application on the allegation that the alleged contemnor has willful and deliberately violated the order passed by this court dated 27th of March 2025. Counsel for the petition submitted after the order passed by this court, the same was extended from time to time. The order was also communicated to the alleged contemnor, and the alleged contemnor has entered appearance in the matter. And in his presence, the order of injunction was extended from time to time. In spite of though the interim order was passed by this court on the month of March, on 27th of March 2025, and the same was within the knowledge of the alleged contemnor, But in spite of the same, again the alleged contemptor has published what a news items
On same post on the root of the respondent number 2.
articles making the same allegation against the petitioner. The article published by the alleged contemptor is placed from page 35 to
40. 35 to 41.
Answer the submission made by the counsel for the petitioner peruse the publication article published by the alleged contemptor. This court find that the alleged contemptor, in spite of having the knowledge that this court has passed an ad interim injunction and which was extended from time to time, but again the alleged contemptor has published the same. Accordingly, this is a fit case when rule can be issued. The department is directed to issue rule upon the alleged contemptor returnable on 14th of November 2025.
14th November.
The petition is directed.
Grateful, by Mr. Ray Miller.
The petition is directed to
Okay.
for issuance of rule.
Obliged to you.
Very good. Very good.
Next.
That 7 and 8, my lord, I appear for the plaintiff. My lord, your lordship was hearing the application, my lord, for grant of interim release.
Yes.
Now, my lord, the application that had been made before your lordship, that is GA number 3, that was for stay of suit under the provisions of section 10. Now, my lord, your lordship will remember that, my lord, your lordship had passed an order staying the suit. But, my lord, we, my lord, preferred an appeal where, my lord, the appellate court clarified that, my lord, stay of suit does not mean stay of interlocutory proceedings. My lord, there are, my lord, 2 judgments also in that regard, but I don't wish to trouble your lordship with that because, my lord, that is now an order, my lord, that is already there. The question, therefore, that fell for your lordship is, my lord, whether, my lord, the interim orders can still be granted. Now, my lord, so far as the suit is concerned, if your lordship will please have a look at.
The stage of the appeal now. It's still pending.
Well, the main appeal is pending. Your lordship is right. The question appellate court will decide whether, my lord, the suit has to be stayed under section 10 or not. Because your lordship has stayed the suit.
Correct.
Now, my lord, appellate court has also said that stay of the suit will not, my lord, ipso facto mean stay of, my lord, the interlocutory application. So, my lord, I can also pray for reliefs. Then, my lord, the question that fell from your lordship, and very rightly so, is, my lord, what is the scope of the suit and what is the scope of the interlocutory application, and whether, my lord, if the relief in the interlocutory application is granted, it will amount to grant of reliefs in the entire suit. Now, my lord, there is already a prima facie finding of, my lord, the urgency with which the matter needs to be visited, because, my lord, an attempt is to make to, my lord, disrupt our rights. So, my lord, we need interim protection. Now, so far as the prayers in the suit are concerned, if your lordship, my lord, remembers, my lord, this, my lord, suit concerns, my lord, a property which is, my lord, number 13, Nelly Shungupta Sharuni.
Yes.
My lord, there was a deed of conveyance executed in respect to this property on the 5th of April 2003.
My lord, I would seek my lord's leave, my lord, for a moment, my lord. But Mr. Mukherjee has some inconvenience today. And he has not come to court, number one, and there is also a resolution of the Bar Association, my lord. Kindly takes it up. As this is a matter assigned to your lordship, my lord, there is no difficulty for being taken up by your lordships and completed by your lordships.
That's why I'm asking since
My lord, I leave it entirely to your lordship. But, my lord, I know your lordship's sentiments with regard to, my lord, these, my lord, requests. So, my lord, I am here before your lordship to make, my lord, my arguments.
But Mr. Mukherjee wants to add, my lord, hardly 10 minutes.
Then
hardly 10 minutes we require, my lord.
14th?
Any day.
14th is fine, my lord. Yes, 14th.
अनुतोष 14 को 2 बजे कोई फिक्स है क्या? फिक्स है 2 बजे रख. I am fixing on 14th.
Very well. Well, as soon as Mr. Mukherjee finishes, I shall also answer.
Probably it will make part heard. The bench has changed.
No,
now.
this is an assigned matter. This is an assigned matter, Mr. Singh.
Assigned. Assigned.
That matters, non-commercial matter on 14th. After that, we'll see what.
But if possible, my lord, any day other than Friday.
So, because by sitting here, I don't know what will the
Well,
position.
let it be there on the 14th. Well, let us come back.
Not then we'll see.
Very well. Lordship, no problem.
Well, both 7 and 8, well, they're identical matters.
As per the prayer made by the counsel for the defendant, let the matter appear on 14th of November 2025 at 2 p.m.
Grateful.
I'm great.
Seven, eight both, huh?
My lord, in item number 9, I appear for the plaintiff in this matter. The GA1 is a demerit application that has been filed by the defendant, challenging the cause of action on the basis that there's an arbitration clause contained in an MOU. So the matter is referable under sections 5 and 8. And the matter was argued at length. Our contention is that since the subject matter of the suit is something which is not can be related or traced back to the MOU in question, the MOU was relied for two purposes. The first was that the agreement, your lordship, on the relevant day when the cause of action took place was not a subsisting agreement, number one. And secondly, in any event, the subject matter of the suit cannot be equated to one as contained in the arbitration clause, your lordship. And accordingly, the cause of action is not related. There's no chain of causation between that and that of the arbitration agreement, which is contained in the MOU. So accordingly, the civil court would have jurisdiction to entertain the proceedings. So there were certain judgments which were supposed to be cited. So I don't know, my learned friend is here.
I thought
so I'm moving, your lordship. I'm moving. But since there's a resolution, so I was waiting for my learned friend to be here. I believe Mr. Ray was arguing this matter and they wanted to cite some judgments. So that's why we had paused.
We can proceed with
My lord, they can cite their judgments and we are also ready with our matter. So we can deal with the judgments and we also have about 4 to 6 judgments to show to your lordship. So when your lordship wants, we are at your disposal for this.
Let me complete first. It is your application.
my application. The lordship will kindly take note GA1. I'll only place a few paragraphs of the plaint which is annexed to this application.
Yes.
The paragraph 3, the lordship will kindly first take. Lord, may I only seek for one indulgence? Lord, Mr. Anirban Ray is leading me in this matter. Lord, he's probably some difficulty. I'll start the matter. I have no difficulty.
Or come on the next day.
Very well.
He will also.
My lord, this matter was argued at length. I don't want to intervene. Argued at length by both sides. So we didn't want to go into the factual matrix of the matter. It was just kept for showing the judgments. However,
placing the facts so that it comes to your
however, to recapitulate, if your lordship wants to briefly hear out the matter, I have no objections. If your lordship wants, I can also show the relevant paras from the plaint just to satisfy the test
at the time of when you are.
You can come.
Very well. As your lordship, I keep it at your lordship's.
As per the prayer made by the counsel for the defendant, the case is adjourned. Let the matter appear on 21st November.
My lord, just one indulgence. This matter has been adjournments have been sought for this matter on the behalf of defendant, and we also have a GA3 which we can't move naturally unless the.
What is the GA3?
That's for injunction, your lordship. That is my application, which is GA3. So just because of the demerit, unless
here only this court is only having the GA1.
My lord, kindly records that no adjournments will be granted on the next occasion. I won't want, lordship is already burdened and you're,
Come on, 21. Come on, 21.
Yes, we'll come.
Yes, next.
I'm grateful.
Lordship, item number 10, GA4 is my application. We've effected service, but the consignment has come back as addressee left. So we've got the new address. We may we effect the service and come back, Lordship.
Regarding GA?
Yes, Lordship. Lordship, the sequence of events is slightly embarrassing, Lordship. Suit got dismissed. I filed GA2 for restoration of my suit. Your Lordship was pleased to observe that it has been filed out of time, so your Lordship suggested we file an application under Section 5. The Section 5 application, GA3 itself got dismissed for default. So GA4 is my restoration application for GA3. Lordship, I've effected service. It has come back. Let me just serve and come back, Lordship.
Counsel for the plaintiff submitted, though the plaintiff has sent the notice upon the defendant, but the same was written unserved. Accordingly, pressed for time to take appropriate step for service of notice upon the defendant. In view of the submission made by the counsel for the defendant, counsel for the plaintiff, the case is adjourned. Let the matter appear on 19th November.
And Lordship, my GA2, that is restoration, that's appearing in your Lordship's list as item number 24. So the same order may be passed.
Item number?
Item number 24, Lordship, in your Lordship's list, today's list.
Is it special assignment?
No, Lordship. It's a recalling application from your Lordship's order of dismissal.
19 बोला ना, 21 कर दो. Along with IAGA number 2 of 2025 in CS 119 of 2018.
Grateful.
Yes, next.
May I have the privilege to address this 11. This is that probate matter.
Yes.
Three sisters, the property of Mother Millard. Today, Millard, we are here, Millard, there is an application. Lordship may recall, Millard, that the executrix, Millard, eldest sister, Millard,
passed away.
Yes, we have taken out a substitution application. Now, my lord, there are other aspect is this, my lord, that on the previous day, my lord has appointed, my lord, my client's advocate on record, my lord, to oversee the property and to collect rent for the time being, my lord. Interregnum, my lord, that your lordship may pass further suitable orders. Now, my lord, we have taken out. Now there is, my lord, lordship wanted charta kotha hai. My lord, lordship requires, my lord, a chart that how much rents, my lord, are
that the commissioner of the administrator is doing, the special officer is
yes.
doing
Well,
that.
this is
you are collecting.
Just I have opened the account and I have given notice to all the parties to send the rent from August 2025, my lord.
So you are not collected still?
No, my lord, yet
Why?
not. I have first I have opened the account.
It's a good place. You go and visit.
My lord, if your lordship directs, definitely I will.
This is a chart, my lord. Or a copy though.
Yes.
My lord, kindly see, my lord, the first page. Now, my lord, one interesting point, my lord, I must, my lord, bring it to my lord's notice. So far as the post office is concerned, it is a cash. How could it be? I do not know. Now, my lord, BSNL, Sudipta Maiti's direct account, PNB, first one, Sudipta Maiti's direct account. Then, my lord, from 4 onwards, Shambhu Das, my lord, their cash. Then ICDS, Sudipta Maiti's direct account. Then all other private, my lord, parties, my lord, paid cash. This is how, my lord, we have also gathered, my lord, apart from the cost papers of this, my lord, proceedings. Now, my lord, down the line after this green, my lord, there's in the blue ink, my lord, we have also found, my lord, from 2013 to 2019, there was a payment made by PNB to the deceased Dipti Maiti's account. Those are, my lord, yet to be accounted. And other than, my lord, this top of this 46,36,531. These monies, my lord, are not, because we have not got anything. Now, my lord, so far as ICDA is concerned, we have put in a red ink. They have not paid, my lord, this much of amount. I, my lord, pray, my lord, a suitable direction to ICDS, because they previously appeared.
You do first what I propose you to.
My lord, my lord.
allowing you this application for substitution.
Yes.
The legal years come on record.
My lord.
Legal years come on record, and you.
No, these are only for the purpose of collection of rent.
Correct. I know. For the present, I pass an order, he will collect. And you come with the total an affidavit, all these things.
Very well.
The appropriate order can be passed.
Very well.
So that their legal years can also go through whether what about the cash? Who will give the answer?
Very well.
The legal heirs only
No,
have to
these part of these cash payments, my lord, were already there in your lordship's record.
That's why the
So, my lord,
answer is to be
and Sudipta Maiti, my lord, during her lifetime, my lord, also purported, my lord, alleged to say that these are the monies, my lord, I had to invest for repairing the building, etc. Lordship knows, my
for
lord.
this purpose. I have not decided earlier.
Yes.
Because I want.
And my lord, kindly turn to the next page. Just 30 seconds more, my lord. These are the few persons who, my lord, were there in the property, and during the pendency of the proceeding in your lordship's court, they were thrown out. So these monies, my lord, are 6,73,200. This also has to be taken into account.
That's like what you come with an affidavit.
Very well, my lord.
If
Very
the legal heirs will come and contest,
Very
then they will give to answer. Otherwise, they have to be summoned.
Because Sudipta Maiti has already said, her affidavit is already there. Now, my lord, so far as this application is concerned, my lord, affidavit of service টা কোথায় জমা আছে? Affidavit of service টা এইটার। My lord, affidavit of service, my lord, I'm told, my lord, we have given them notice.
You have disclosed the this postal receipt, but where is the track report?
Yes, কোথায় সেটা? না।
Where is the track report? Have you obtained the track report?
দেখালো তো এক্ষুনি। No, my lord, what I am told, on 24th, the post are made.
Correct.
But till today, whenever, my lord, they, my lord, try to open from the server, nothing is shown. And service is affected on both the addresses. If it is service আমাকে দেখিয়েছে, সেটা কোথায়?
Okay, this is a substitution. Let the substitution be allowed. You issue the notice.
Very well. I shall agree.
After the substitution, you
My lord, kindly have a look to this, my lord, for my lord's own satisfaction. I have checked it. There are two addresses, one at Kolkata and other one is West Midnapur.
Yes, it is here.
Yes.
It is here, but track report is not there.
Yes, but I am told, nothing is shown. Even nothing there to.
I am allowing this after the amendment.
We shall give them notice.
It is to be given.
Very.
You are the applicant.
Yes, madam. Sangita Maiti. I am the youngest daughter, madam.
The petitioner Sangita Maiti had filed the present application being GA4 of 2025, praying for deletion of the name of the executrix Sudipta Maiti, alias Sudipta Maiti, 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 who died on 14th August 2025, leaving and for substitution of a legal heir, namely Dr. Subrata, Subhar, Subhabrata Maiti, being the husband, and Sri Kapanil Maiti, being the son of the deceased. Consider the submission made by the counsel for the petitioners. Produce the materials on record. The department is directed to record the death of Sudipta Maiti and to substitute the husband and the son of the Sudipta Maiti as what capacity they are having as the legal heirs of
legal heirs.
As the legal heirs. The department is directed to complete the same within a period of 2 weeks from date. After the order is carried out, the petitioner shall file amended application. After being an amended application, after verification of the readings, and to serve the amended copy of the application to the substituted legal layers of the executives within a week thereafter. Please the matter.
My lord, I am told, my lord, 21st already the matter is fixed. The hour the application for removal.
The matter on 21st of
21st.
November 2020. Come on 21st.
After 3 weeks. Well, my lord has said that.
Disposed of, huh?
Yes. Well, one sentence, my lord, if lordship pleases, my lord, that in the meantime, my lord, the tenants are directed to pay the
That already there.
Very well, very.
The first order all has been clarified. Your special officer will take care of it.
Very well. May I just take back the copy and file along with an affidavit? I am grateful.